ready? Testing, testing.
Okay. But for folks who are joining us.
Okay.
Mr. Hopick, if you can hear us, please test your microphone.
Mr. Chen, I can hear you. Can you hear me?
Yes.
Good morning. This is the Rulemaking 80, the Montgomery County Community Choice Aggregation Pilot Program. We'll start with taking appearances.
Good morning, Chair and Commissioners. Peter Wilson from Staff Council. Also from Staff Council in the gallery is Kenneth Albert. Here to my right at the table is Philip Vanderhayden, and appearing by video is David Hopick. And then finally, I mentioned this to Mr. Chen, Lloyd Spivak, Staff Counsel, is available on short notice if and when the Commission is ready for a status update on the PIP proceedings.
Okay.
Good morning, Chair Hoover, Commissioners. My name is Lisa Brennan, Associate County Attorney for Montgomery County, Maryland. And with me today to my left is Stan Edwards, Chief of the Energy, Climate, and Compliance Division of Montgomery County's Department of Environmental Protection. And also with us today is Michael Krauthammer, Managing Director of EV Advisors.
Good morning, Chair Hoover, Commissioners. David Lapp, People's Counsel here on behalf of the Office of People's Counsel. It's a pleasure to be before you today. Thank you.
Hey, good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker here on behalf of the Retail Supplier Coalition, which consists of NRG Energy Inc., Interstate Gas Supply Inc., DBA, IGS Energy, Constellation New Energy Inc., WGL Energy Services Inc., and Vistra.
Good morning, Mr. Chairman and members of the Commission. I'm Fran Francis, appearing on behalf of the Apartment and Office Building Association of Metropolitan Washington.
Go ahead.
Oh.
Oh, okay.
Good morning, Chairman and Commissioners. Assistant General Counsel Taylor Beckham, appearing on behalf of Potomac Electric Power Company, PEPCO.
Good morning, Chair Hoover and Commissioners. Beverly Sokora on behalf of Baltimore Gas and Electric Company.
Good morning, Mr. Chairman, Commissioners. My name is Jeffrey Trout. I am counsel to Potomac Edison.
Good morning, Mr. Chairman, Commissioners. James McGee with the Law Office of Robert Castro on behalf of Prince George's County, Maryland.
Okay, I guess that's everybody. The only preliminary statements I'm going to make is just to let everybody know that there is a distinct possibility that we will defer some issues to a future rulemaking. I understand that everyone has made a lot of work in this proceeding. There's been a lot of progress made, but you know, obviously the fact that there are 3 new commissioners who are brand new to this proceeding and process, I just want to alert folks that there's a possibility that we'll decide to defer some of these issues. My intention is to try to get as much done and as much decided today as we can, but there may be a chance that some issue gets pushed to a future rulemaking. And with that, I'll turn to Commissioner Bartlett.
Thank you very much, Mr. Chairman. I'm very committed to this program working well for the ratepayers of Montgomery County. There are some issues where I have some concerns, Mr. Chair, so especially with respect to notification of prospective enrollees. And so at that point, I may slow the tray down a tad bit so that I can ask some questions, but that's really the only thing I wanted to say, because that issue is top of mind for me. Thank you, Mr. Chairman.
Commissioner Richard.
Thank you, Chair Hoover. I really didn't prepare any opening statement other than to note this is, for me, my third attempt at this. So I hope that we can get as far as possible. Fingers crossed, maybe we can even get it done today. But I think my positions are pretty well known at this point, and so why don't I just state again, I believe this is an important act of the legislature. They wanted to grant Montgomery County this opportunity to form a CCA, and I believe that the intent is to provide them the tools, the authority to do so. And so I will continue to largely be very deferential to the views of Montgomery County, since it's on them to make this work. And so I believe that to the extent possible, I'd like to hand them regulations that will allow them to succeed. So with that, I thank you, and I'll keep my fingers crossed again that we can get as much done today as possible.
Commissioner Suchman.
Thank you, Chair Hoover. I am one of those new commissioners that the chair has referenced, and so I'm new to this process. I share my fellow commissioners' excitement over the possibility of this aggregation going forward. I can just sort of give you a sense that I'm a little bit concerned about protecting the ratepayers of Montgomery County to the extent that there is a problem, and I want to make sure that the regulations reflect that. It's always I'm a lawyer, so I always like to have guardrails in place to the extent that there are potential issues that come up. 99 times out of 100, everything is fine. I always look to that 1% to make sure that if there is a problem, the ratepayers are also protected in the regulations. So, thank you.
Commissioner O'Donnell.
Thank you, Mr. Chairman. I will just say it's been a long, hard slog to get to this point. Not only do we have to protect the ratepayers of Montgomery County, because I agree with Commissioner Suchman, but we have to protect the interests of all ratepayers in the state to make sure there's not burden shifting or risk rolling to other places that don't receive the direct benefits of such a program. In fact, there has to be shown some tangible benefits, not some amorphous, well, it's a pilot, so we're going to learn from it. Now, if there's financial risk, then there has to be financial benefit, in my opinion. Two, having said that, we need to make sure that the ratepayers of the state are not carrying load that they otherwise would not have carried. So there are other concerns that I have that have caused us to stumble some here and there. I'm hopeful we can get there. We've tried in good faith, as have a lot of people. It's been a tough slog plowing new ground here, but I'm hopeful we can get there in accordance with the statutory directive. So thank you, Mr. Chairman.
Thank you. Let me turn to Mr. Chen. Do you want to discuss the agenda, what we're going to try and do today?
Good morning, Mr. Chair and Commissioners. Joey Chen, Commission Advisor. I will be the one shepherding today's rulemaking. Yes, let me just bring up the agenda. Here we go. So this morning, before we begin with the walkthrough of the proposed regulations, Montgomery County has requested an opportunity to make a 15-minute presentation to the Commission regarding an overview of the CCA. It is my understanding that this presentation is intended to be informational and educational only. The county has spoken with the parties, and I am told that none of the parties here today object to this request. So, without further ado, I will turn over to Ms. Brennan. I have the slides ready to go whenever you'd like to begin.
Thank you. Stan Edwards will be doing the presentation today.
I will try to get it larger.
Good morning, Chair Hoover and Commissioners. As Ms. Brennan said, my name is Stan Edwards, and I'm with the Montgomery County Department of Environmental Protection. Thank you for the opportunity to provide a few remarks at the beginning of today's rulemaking session regarding regulations for the Montgomery County Community Choice Aggregation Pilot. I will be brief, less than 15 minutes, and do not intend to reiterate any of the specific comments we have made regarding the CCA regulations before you today. There will be ample time for that. Rather, we thought it was important that we provide some background on the rationale for Montgomery County's interest in a CCA and the lens through which we viewed the proposed regulations. As we have noted in filings and discussions related to the CCA, in 2017, the Montgomery County Council declared a climate emergency, setting very ambitious greenhouse gas reduction goals, including the elimination of community-wide greenhouse gas emissions by 2035. Some have said these goals are unrealistic, and indeed the county has struggled at times to reconcile these goals with the specific policy actions required to meet them. Nonetheless, striving to achieve them, along with other like-minded entities, including the state of Maryland, is the only realistic path forward if we are to avoid the worst impacts of climate change. Indeed, in 2023, humanity seems to be the frog in the proverbial pot of water that has reached the boiling point. As July 2023 looks to be the hottest month ever recorded, droughts create conditions that lead to wildfires that threaten air quality and drinking water supplies, while at the same time intense precipitation causes devastating floods throughout the world. Community choice aggregation in Montgomery County won't solve these issues, but it is an important piece of a very large puzzle that we hope others will be able to emulate. Community choice aggregation Community choice aggregation was among the key recommendations in Montgomery County's 2021 Climate Action Plan. Thanks to the efforts of Delegate Laura Charkoudian and her colleagues in the General Assembly, including Commissioner Barve, in 2021, House Bill 768 authorized the creation of a pilot CCA in the county. We have worked diligently with and are grateful to the many stakeholders in the room that have spent many, many hours proposing regulations to make a CCA possible. While new to Maryland, CCAs have existed around the country for many years. Historically developed primarily to provide cost savings to customers, they are increasingly being used to achieve policy goals, such as increasing the use of electricity from renewable sources. Through the CCA pilot, Montgomery County seeks to achieve both these important outcomes. Next slide, please. Thank you. Sorry. As you are aware, there are a number of significant steps that must be taken before a pilot CCA can begin to deliver power to customers in Montgomery County. The CCA work group, created by the statute, must draft proposed regulations which the Commission must consider, modify as you see fit, and then adopt. The county must develop an aggregation plan, share it with the customers the CCA would serve, and present this plan, along with a draft local law authorizing the formation of a CCA, to the Commission for review and approval. The aggregation plan, once approved by the Commission, will be the operating manual of the CCA and is fully enforceable by the Commission. Several key themes have arisen during the regulation development process that we wanted to highlight as the Commission, with 3 new members, takes up these regulations. The first of these is the structure and governance of the CCA. Next slide. While the specific details of the CCA's governance have not been fully defined, we can say with certainty that the CCA will be an instrumentality of the Montgomery County government. It will be subject not only to the Commission-approved aggregation plan, but also to existing county laws, regulations, and procedures governing accountability, procurement, privacy, cybersecurity, among other important operating principles. Most importantly, will operate on behalf of and for the benefit of the residents of Montgomery County. We envision the governance structure of the CCA will be similar to the structure and processes overseeing the county's employee retirement plans, which involve the management of nearly $5 billion in assets. CCA's governance will be structured in accordance with the required county law, managed by a board of trustees or similar oversight body, and subject to published governance procedures, program policies and objectives, standards of conduct, and other fundamental operating principles. A second theme that has been discussed extensively during the course of the CCA work group is the fact that the CCA provides a new electricity supply option for Montgomery County residents and small commercial customers. Existing options, standard offer service from electric utilities and retail electric supply, are well understood and operate, for the most part, effectively and efficiently. Through SOS, utilities contract with wholesale suppliers through a well-defined four-cycle procurement process that results in stabilizing fluctuations in electricity rates. Alternatively, customers can contract with a retail supplier authorized by the Commission to do business in Maryland. Both of these options will remain in place and be available to customers following the commencement of the CCA. The Montgomery County CCA will offer residential and small commercial customers in the county a third option for their electricity supply. Through the CCA, the county will contract with an aggregation supplier, which will be a retail supplier authorized to operate in Maryland, to provide service offerings consistent with the county's twin goals of increasing the use of renewable energy above that currently required by Maryland's Renewable Portfolio Standard at a price comparable to standard offer service. Stable and cost-competitive electricity pricing is fundamental to the CCA's success. Instances of failed CCAs that have occurred have been primarily driven by the lack of a well-defined, long-term electricity procurement strategy. In order to achieve stable and cost-competitive pricing, the CCA's aggregation supplier will forward procure energy following the terms of its contract with the CCA on essentially the same schedule as SOS procurement by the utilities. This approach, commonly used by other successful CCAs, will minimize customer migration away from the CCA, maximizing stability of both the CCA and SOS. A final theme that I wanted to highlight has been the subject of considerable discussion with the work group and the Commission relates to customers' interaction with and options under the CCA. All residential and small commercial customers in Montgomery County will be eligible to participate in the CCA. Customers enrolled with a retail supplier will remain with the retail supplier and will not be enrolled in the CCA. No action is required to participate in the CCA. The CCA is opt-out, meaning customers who are currently on SOS and do nothing will be automatically enrolled in the CCA. The CCA will offer various levels of clean and renewable energy. Customers are free to change their CCA supply option anytime with no penalty, as there are no contracts between customers and the CCA. To opt out of the CCA, which a customer will be able to do at any time, a customer can notify the utility or the county of their choice, or enroll or maintain their enrollment with a retail supplier. Because the CCA is a function of the county government, we view clear communication with customers as obligatory. At any time, customers must have access to the different offers of the CCA, the pricing of those offers, and the terms and conditions of those offers. In addition, they must be able to clearly understand their other options and have clear directions on how to access those options. The CCA will have a simple but informative website that will be available at any time for customers to learn about the CCA. Screenshots from other successful CCAs are shown on the slide. Information about the CCA will be provided in other formats as necessary and made available in different languages. The website will provide clear information about a customer's options and how to contact the CCA regarding any questions or concerns they may have. We believe this will, in conjunction with a well-defined electricity procurement strategy, result in a stable CCA for Montgomery County customers and offer a path that others in the state may follow in the future as we collectively strive to maintain a safe, reliable, and cost-effective electricity supply system for Maryland while addressing the existential threat of climate change. This concludes my remarks. Thank you for the opportunity to present them. We would be happy to address any questions you may have.
So we'll start with Commissioner Richard. You have any questions?
No questions.
Commissioner Barve.
None yet.
Okay. Commissioner Sushman.
Yeah, I just have one. I should turn this on. I have one question, which I suppose I would have gotten to later, but might as well get to it now. So you mentioned that the price needs to be comparable to the SOS, and yet in the regulations, if I can find it, so I'd have to go through. Joey, maybe you can help me. I think the regulation required that the service offer be better than SOS. Was that your I mean, and maybe I'm mistaken, but I thought that in the regulations, when you're proposing the aggregation plan, required that there be a demonstration that I'd have to go through it. I wasn't prepared to talk about it now. Joey, does that sound familiar to you? Oh, here it is. A description of the purchasing plan designed to save ratepayers money. So this is in 20XX.11. So this would be the aggregation plan requirements and application process. So, and maybe we can get clarity now, or should we wait and get clarity later? But I'm trying to understand when you're putting together the aggregation plan, is the expectation that the notification to customers would provide that the price is going to be comparable to SOS, or that what you're offering is going to save the money? And that's just because if it's in the regulations, we need to, and that's not the case, then the regulations need to change.
So I'll start, and then Ms. Brennan may have some comments. The CCA's prices will not always, may not always be less than SOS. Over the long term, CCAs try to have prices that are less than SOS. The statute asks that the aggregation plan define how the CCA will procure electricity in a way that saves ratepayers money. We don't perceive that as meaning that the price of electricity is always less than SOS. It's that we have
Okay, then for my purposes, I don't know how the other commissioners feel, but the language then needs to be made clear that the purchasing plan, the language needs to be changed so that there can be a description of how the purchasing plan could save. I mean, something that would suggest that the purchasing plan is not required to save customers money. Do you understand how I'm reading that, and why there would be confusion if someone were to be looking at this regulation and not understanding the larger picture of CCA? Yes, Ms. Brennan.
Thank you for pointing that out, Commissioner Suchman. I think the language in the regulations mirrors the language of the statute, which is that it refers to a purchasing plan designed to save ratepayers money. But if you think that's not clear from the regulations, we can certainly address that when we get to that point.
Okay, thank you.
Thank you.
I would just add that I described briefly the procurement approach of the CCA to mirror SOS. We could, and some CCAs do try to beat the market, if you will, and purchase electricity at opportune time.
This is mostly just because if we're going to have regulations to implement it, we need to be clear that the plan doesn't require that the option beat SOS. That was my only concern. Okay.
Commissioner O'Donnell.
Nothing now, Mr. Chairman. Thank you.
Okay, thank you. Let me ask a couple questions about the organizational setup. You had mentioned that this is going to be you said instrumentality of the Montgomery County government. So I guess what I'm trying to figure out is this going to be a separate entity within the Montgomery County government, or does it fit into some department?
I would suggest it fits into multiple departments, and therefore there would be probably a department designated for sort of day-to-day administrative procedures, but it would be overseen by a board of trustees or some organization like some group like that that is made up of representatives of, I can imagine, the Department of Finance, the county attorney, the Office of Management and Budget, and other key departments that would be have an interest in the functioning of the CCA.
So the Board of Trustees is going to be people who are currently employed by the Montgomery County government as opposed to outside citizens.
It could be both. So the Board of Investment Trustees for retirement funds, for example, includes both representatives of the county government and outside entities to ensure that the county's tax dollars and the employees' retirement funds are invested wisely. So,
And maybe you haven't made the decision yet, but I assume there'll be, an executive director or some chief executive officer of the CCA.
we haven't made a decision on that. I would expect there would be some person who is in control of the day-to-day functioning of the CCA.
And there was some discussion in the regulations about, in case a customer wants to contact the CCA. So is it going to have its own staff, or is it going to rely on the staff of other functions of Montgomery County government?
Well, there could be several ways that happens. We will certainly, so the county has a 311 system that we would certainly utilize because that's a known entity for people to contact the county government about any issue with the county government. So we would arm the 311 system with information about the CCA, but ultimately they would be talking to someone with more expertise. They would be directed to staff who are familiar with the in and out operation of the CCA. And we certainly probably rely on the expertise of our aggregation supplier as well to support that function, but we do feel it's very strongly that the county is the face of the CCA. Questions should be directed to the county. The county will be the first stop to resolve issues. And certainly, if issues can't be resolved, the commission obviously has the authority to solve those issues. But we want to provide the level of service that we think the residents deserve in the county.
Okay, thanks. Now, my understanding that the Office of People's Counsel wanted to make a couple of comments before we got into the regulations.
Oh, Mr. Chairman, if I just, as a follow-up to the questions that Chair Hoover was asking, and sort of going back to the regulations 20.xx.05, there's a reference to an energy service provider, and there's no, it's not a defined term as much as I could tell. Is your thinking that an energy service provider may be something other than the county? In other words, are you thinking that it's possible that you may retain an administrator like they do in New York?
That's possible.
Okay.
Yes.
Okay. Thank you.
Okay, Mr. Lapp.
Yes. Good morning. Appreciate the opportunity to be here today. I'll be pretty brief. I wanted to first say I'm here pinch hitting for Bill Fields. I have unfortunately not been part of the working group process myself. I'm doing the best I can to keep up. And I wanted to just provide a few general comments to start and talk about what we think should be the primary goal here. And we think the primary goal here should be to help the CCA work, to make it succeed. Retail choice is not benefiting large numbers of residential customers. We know only about 20% of customers shop, and many of them pay much higher rates than the standard offer service. And we know many of them are targets of abusive marketing practices. CCA can help relieve some of that. It's a pro-consumer project that can harness the buying power, the collective buying power of residential customers in the way that individual retail choice cannot. I was looking yesterday, and as I was reading some of the materials for today, and I saw on the EPA website has a list of community aggregation advantages, and those advantages on the EPA's website include potential retail electric rate reductions, rapid shift to greener power sources, local control of electricity generation, which can be responsive to local economic and environmental goals, expands consumer choices, and can spur local jobs and renewable energy development. I would add a sixth, and that is that CCA can help provide a benchmark for retail suppliers for the services they provide, as well as a benchmark for the utilities for their provision of SOS and energy efficiency services. So the CCA can benefit other customers in Maryland by providing that competitive benchmark. Turning more specifically to some of the issues we're going to be facing today and talking about today, there seems to be a sort of an underlying premise behind many of the disputes, and that is the connection between the CCA and a retail supplier. And CCA is not a retail supplier. And that's evident right there in the statute. The statute, retail suppliers are subject to all the different requirements in Title VII, and the CCA expressly in the statute, the General Assembly said that the CCA, quote, may not be considered to be an electricity supplier. So this is important to keep in mind. The General Assembly said, no, the CCA is not an electricity supplier. And there's good reason for that. The first is accountability. The CCA is accountable to the institutional protections and really to democracy in Maryland. Retail suppliers are just regulated by the commission. Another way that retail suppliers are different, retail suppliers may have no physical presence in Maryland. They may have no employees in Maryland. The CCA, of course, is part of Maryland. And finally, retail suppliers are motivated to charge high prices to increase their own profits, and that comes at the expense of customers. The CCA, on the other hand, is motivated to succeed in reducing prices for customers who are also the CCA's citizens. For the most part, OPC is comfortable with Montgomery County's position on most of the issues. I think the comments provide a few instances where we might feel a little differently or be indifferent as to whether staff or Montgomery County's positions are appropriate. I wanted to just point out three different points that we think are important. First, requiring consent and a contract for optional service provisions as proposed by staff. We think it's important that Commission reject that. It's premised on the misplaced notion that the CCA is like a retail supplier. The CCA does not need to enter into contracts for optional services. Second, relatedly, the Commission should not require advance notice and approval of changes, whether those changes are to basic or optional services of the CCA, material or non-material. Again, that's premised on this notion of equivalence between the CCA and retail suppliers, which is not in the statute and does not make sense from a policy perspective. The third is the procurement issue. We're very concerned about the procurement, and we're working on this very hard in the PIP working group. We are working to make sure that Prince George's County and other non-CCA customers are not materially impacted by the CCA. We want to provide the best path for the CCA to succeed for Montgomery County customers that opt out of the CCA, as well as the non-county customers of standard offer service. But again, we think that should be addressed in the PIP process. On most of the issues, again, we're in support of Montgomery County's position. Overall, if the Commission has discretion and the policy plays out either way, we think that you should defer to the Commission or to the county's proposals. With that, look forward to the discussion today. Thank you.
Any questions? Alrighty, with that, we'll turn to Mr. Chen.
Thank you, Chair Hoover. Okay.
Mr. Chair, can I just ask Executive Secretary, is it possible for us to turn this screen on over here?
Oh.
Oh, great. Thank you.
Yeah, I can.
Yeah.
Thanks a lot.
Sure.
There's that one, yeah. So.
Your Honors, for the walkthrough today, I will be putting up a Word document version of the proposed regulations. You will see in the edits and comments that there are some color coding. Just by way of general explanation, the color green will represent the views and positions of Montgomery County. The color blue will represent those of Commission staff. Gray will represent those of Lori McGilvray. And then the color yellow is just in general for the other stakeholder participants in the work group. Now, I will be taking the regulations out of order. And the reason for this is because there are a few consensus regulations around which there are no dispute, which I believe the Commission can work through rather quickly. And then there are regulations that tee up a series of moderate issues, about 10 or so. And then there are regulations that tee up much more significant issues. And it's my recommendation to the Commission today, as you see from the agenda, that the Commission first proceed with the consensus regulations and then the moderate issues, which do follow loosely a flow of how the CCA works, and then, time permitting, the more significant issues. So I believe we can turn first to regulation, Chapter 3.
Joey, are we skipping chapter 2,
There is no Chapter 2.
definitions?
That's Chapter 1 under definitions. I think Chapter 1 will probably be best reserved for the very end, because there are some definitions in Chapter 1 that will be either accepted or adopted or rejected depending on how you rule on some of these other issues.
Thank you.
So turning first to your attention to Chapter 3. Chapter 3 concerns the pre-enrollment information. There is one staff pointed out one typo correction that needs to be made. We'll get to that in a second. But this chapter covers the information that must be provided by utilities for CCA pre-enrollment, and that includes customer account pre-enrollment information and information for the CCA formation and opt-out notices. My apologies. Okay. So I will turn to staff briefly. I believe I saw that there was a correction that staff wanted to make in this particular chapter.
Yes, thank you, Joey. Mr. Chair and Commissioners, if you look at 20XX0303F, there's that line there should have the words. It reads, a county may not request the information in section C2 of this regulation, and it should say prior to the effective date of this regulation.
Your Honors, that is the only edit for this chapter. And I'll turn it to the Commission if the Commission has any question for the parties, concerns, issues they want to raise to the parties directly.
Any questions? Okay.
So, Mr. Chairman, just a point of clarification. Would you be taking up a vote how would you like to take the vote? Would you like to proceed on a chapter by chapter, or would you like to wait until the end and do a package vote at the end of the day?
So, how have we done this in the past?
Well, Mr. Chair, sometimes the more contested issues, we may want to poll the commissioners to have a sense of which direction we're going, and that may work best. But in other circumstances, like here, it appears that there are no issues, so we probably can just go ahead and deem that as adopted, and then we'll take the final vote for the entire package. Right.
Does that work for Mr. Chen and the parties, that process?
I have no objection there.
No objection.
Okay.
Yeah.
Okay, then
And maybe just also a reminder to the parties that when we are at a section of interest to that party, they should speak up at that time.
No, I understand.
So,
And so, obviously, and if we get to a point where someone wants to talk about something, just let us know and we'll recognize you. So, all right, well then,
Okay.
I guess we'll move to the next one.
Thank you, Mr. Chair. The next chapter we'll take up is Chapter 15. That's 20XX 15. This chapter addresses the standard for data exchange between the utilities and the CCA. Cybersecurity requirements will be addressed separately under Chapter 16, Data Privacy, as there is a material issue related to data privacy. However, with respect to this chapter, Chapter 15, data exchange in general, this appears to be a consensus item. So I'll leave it to see, I'll look down the table to see if the parties have any questions or any comments they wish to add, and if not, I don't see any. I'll turn to the commission to see if how the commission would like to approach this one.
Any questions on this one? All right. Okay. Moving on.
Okay. The last of the consensus regulations is Chapter 17, and that deals with transition to the CCA from SOS. I do not believe that there are already any red line edits to this regulation as I'm scrolling down through it. The chapter addresses the initial transition of utility SOS customers in Montgomery County to the CCA basic service, including the schedule for transitioning customers to the CCA and the transition reporting requirements. Looking down the table here, there do not seem to be any issues.
Any questions here? Okay.
Okay. We are moving on to the moderate issue. So what I've done with the agenda, rather than listing out all and proceeding directly with a chapter by chapter walkthrough, I've grouped and organized the proposed regulations into issues. So the first issue concerns Chapter 20. And I realize with Chapter 20 we seem to be taking the regulations at the back end here. I'm dealing with the last one first. However, this one does not depend on what the commission decides in terms of the operation of the CCA. So the commission can address Chapter 20 coordination tariff out of order. The chapter governs the coordination tariff that affected utilities will use to establish the requirements for a county service that serves as a CCA. The tariff will also include requirements for the CCA aggregation suppliers and the CCA's agents. These chapter provisions speak to pilot cost recovery. For example, the CCA uncollected cost recovery methods, pilot administrative expense recovery, and the purchase of receivables discount rate. I will be focusing the commission's, instead of just looking at every regulation line by line, I think it'd be better use of the commission's time if I first direct you to the regulations that involve disagreement. And then after that, if there are other questions regarding the consensus portions of this chapter, we can certainly look at those. The first regulation, Regulation 2. You will see in the side comment here staff's position, but let me give you the context for Regulation 2. This regulation addresses the CCA coordination tariff that the applicable utilities will file with the commission regarding the pilot. The as-filed language, the staff's language, the as-filed language you see here represents language reached by agreement of the county and the joint utilities. Staff's position, highlighted in blue in the comment bubble here to the side, states that the time frame in subsection A1 should be within 60 days of final publication of the applicable CCA pilot regulations. And staff believes that 60 days should be sufficient for each utility to develop the appropriate tariffs after the regulations take effect. So with this, I will turn to staff if staff has any additional comments that they'd like to make.
Okay. Just to be clear, what's in the bubble there on the side is not consistent with our position. What you just read is, and it's on page 7 of the staff comments. So I think the only distinction here is we looked at when the utilities are required to make this tariff filing. The final publication of the applicable CCA pilot regulations will be a known date. It'll be a date by which the regs are certainly within effect. I think the concern that was raised about after the commission approves the regulations for final publication, that's not a clear date necessarily. As far as we can see, the commission adopts regulation in the hearing. They go down to Annapolis and they come back up, and then they have a final hearing. We're not clear precisely when 60 days after the commission approves the regulation for final publications would be. However, the language we're suggesting is very shortly thereafter that, and captures the consistency with regulations being effective after they are published in the Maryland Register. So we just recommend it as a easier target for identifying when to comply with, and would prefer to have that. I think it's consistent with the way typically a utility would be required to make a filing consistent and in compliance with regulation.
So question, Mr. Benhagen. So this language in the comment bubble is no longer relevant. Is that?
Yeah, we filed comments July 7th, so that's not consistent with that. We're recommending within 60 days of final publication of the applicable regulations.
Isn't that what this?
What you've got there is within 60 days after the commission approves the regulations for final publication, which is not a well-defined date and is not necessarily something we could start a clock on if that was important at the time. So the publication date would be when it goes into the Maryland Register, and that has a specific date. So 60 days after that, the utilities would be required to make that filing.
That's what this says. 60 days of final publication of the applicable CCA.
Okay, well then that's correct.
Okay. I just want to make sure.
I guess I must have pulled up a version that says within 60 days after the commission approves the regulation for final publication.
Okay, so let me just clarify for the commission. The commission is looking at the highlighted language. Staff's proposed edit is, quote, within 60 days of final publication of the applicable CCA pilot regulations, unquote.
And we don't need to say final publication where people are going to understand what final publication means.
I believe
the understanding is in the Maryland Register, but if the commission wanted to add within final publication of the applicable regulations in the Maryland Register.
Actually, I mean, it may be, overkill, but it probably doesn't hurt, so.
Okay, I believe the parties can work together to clean that up.
Okay. Does that work?
Can I speak to the county's concern on this?
Oh, sure, go ahead.
So the reason that we worked with the utilities to draft the language that's in the main portion of the text at this point is because time is really of the essence. This is something that we think the aggregation suppliers that we're trying to contract with are going to want to know. What are the operating, what rules are they going to be operating under?
Sure.
And it's my understanding that the commission will vote to approve, and that's a known date and a known proceeding and a date certain, as it were. And sometimes there's a delay between when the commission acts and when it makes it into the final register, and that time just that's valuable time to the county and to the CCA. So that's why we worked with the joint utilities on this language that's that's currently in the body of the text.
Well, the only concern I have is that, there is this fairly detailed process, which probably Commissioner Barbe can opine on, regarding, when an agency makes regulations and who it goes before for final approval. And so I guess I'm a little concerned that, publishing in the Maryland Register is kind of like the final statement on it, and I want to avoid situations where people may be raising objections to what we've tried to do on this. So that's why I'm thinking that this publication date, is a pretty clearly defined date in the process, and that anything earlier may lead to some questions from some of these folks about what is the final regulation.
Well, that's why we had the final publication rather than, the approved for final publication versus that initial round, because we absolutely understand that there may be folks that want to comment, and maybe edits will be made after the first notice goes into the Maryland Register and the notice and the comment period. So we thought that but once the commission approves the final version for publication, that seemed to us to be a known date, something that could be counted on, as it were, by the utilities as the launching point.
What's the turnaround time from when we approve regulations and it shows up in the Maryland Register? How much time are we talking about normally?
Are we talking about proposed regulations or after the final action?
After the final action.
After the final action, 10 days until it actually takes effect.
Okay. Anybody have?
Did I misunderstand the question? Because there's sometimes a delay between when the action takes place at the commission and when it gets published.
Okay, I answered the legal effect question. I'm sorry. Yeah, it would be a couple weeks at least.
So, take a couple weeks.
Yeah, at least. Sometimes there's also some things on the back end where there's no actual defined for the publication. Then it's 10 days after.
So he just said.
But they,
Did you just say they take legal effect 10 days?
10 days after final publication.
After final
But after
publication.
we do something final, there's not a defined period of time from when it actually appears in the register.
Right, but there's no more opportunity for objection or comment following the second vote
No.
for that final approval. So that is the language, and the utilities are comfortable with that milestone as the date on which they will base their tariff.
Mr. Trout, is that?
Thank you, Your Honor. Yes, I just wanted to second the comments from the county. Our understanding is that staff prefers a slightly later date, but a slightly more certain date. The utilities worked with the county to arrive at a slightly earlier date, which we also feel is a relatively certain date. in order to accommodate the county. The utilities can do it either way. We can do it after you all vote on the final version of the rules, or after that final vote is memorialized in the Maryland Register, which will come, of course, later. We can do it either way. We stand with the county in proposing what we have proposed because it gives the county access to our proposed tariffs a few weeks earlier. But the utilities can do it either way. So we are, in that respect, able to implement this whichever of these choices you make.
Commissioner Richard.
I'm just going to say I'm fine with the county position. It sounds like it's consistent with the utility position. So.
What, Commissioner Barbe, you got any questions on? Okay. All right, Commissioner Schlesman.
Okay, I'm actually trying to understand the timing of this, and I'm a little confused about why the timing is connected to the regulations as opposed to some other aspect of the program. So we issue final regulations, and then you have, and then within 60 days, the utility, PEPCO, will have to submit tariff language. But then we don't have that connected to the aggregation plan, and that could take a year. I mean, I'm assuming it's not going to take a year, but it could be delayed for whatever reason for long periods of time. And I'm trying to figure out, maybe the utilities can respond to this, whether that tariff language, whether the tariff is going to have to get changed depending on when the aggregation plan is finally submitted to the commission. So I'm just wondering if tying it to the issuance of the regulation is the right mechanism, or the right timing for the issuance for the submission of the tariff language.
Thank you, Commissioner. I'll try to address that, and then if others want to amplify or modify, they should feel free to. So we need the commission to act on final regulations so that we know what language to put in our tariff. I think that's clear. By the same token, the county has made clear to all the stakeholders in the work group that they would like to see not just the regulations but the tariff language before they finalize their aggregation plan for submission to you. So that's why we were trying to move up the tariff language a little bit earlier to accommodate that desire by them. And you're absolutely right that it could happen that when you approve the aggregation plan, that either as a result of what gets submitted or as a result of changes to the proposed plan that you all request and that get made, we the utilities may then have to go back and revise the tariffs, which by that point you presumably will have already approved in their original form, and we will do that. We will figure out how to make that work.
Okay, and the county understands that it's a possibility?
Yes.
Okay, can we just have that reflected in, or do we need to have that reflected in the regulation?
That strikes me, Commissioner, as a level of process detail that we don't need to embed in the regs.
So we don't need to make any, okay, that's fine.
Okay. All right, well, I guess after hearing all that, I'm actually comfortable with this arrangement that the county and the utilities want to do. So it'll be when we adopt the final regulations as opposed to the publication date.
Thank you, Mr. Chair. Let me just make one note.
Sure.
you see there will be the regulations. So,
Approved?
yeah, it will be approved unless you want to make that change then.
Yeah, I think that's probably the correct term.
Approve or adopt.
Adopt. I think that's the way it's used.
Mr. Chair, Commissioners, there's a proposed edit to change this highlighted word from approves to adopt as being the more.
Oh, yeah, it's probably more accurate, so, yeah, I agree.
We have no objections to that.
Yeah.
Okay.
I mean, that is the formal action we take, so.
Okay. The next regulation involves Chapter 18. This chapter concerns the recovery of uncollectible SOS expense from CCA customers. Again, this is taken sort of out of order, if you will, but again, because it is it would impact the utility tariff, and it doesn't bear on the actual operation of the CCA necessarily. There seems to be just a proposed edit by Lori McGilvray, and that's why I'm teeing this particular chapter up first. This chapter it concerns the possible commission allocation of SOS uncollectible costs, as I mentioned, to CCA customers as allowed under the Public Utilities Article 7510.3, paragraph P. And there is just that one proposed edit by Ms. McGilvray. Let me just bring us to that language here. Ms. McGilvray proposes to add the phrase net of the related late fees, as you see on the screen, to clarify that the CCA discount rate, which is used for purchase of receivables, should include a late fee offset, the same as how what is currently the retail supplier discount rate is treated today. The county does not object to this. Staff's position is that Regulation 03 in the as-filed language should be adopted. The proposed edit by Ms. McGilvray is unnecessary to allow for review of the appropriate inclusion of late fees when the tariff is filed. So with that, just look over to staff to see if staff wants to add anything.
Just, again, Phil Vanderheyden, Mr. Chair and Commissioners. I think our concern there is that it sort of implies that late fees will be incorporated as the offset. And you know, it's probably very likely that they would be, but that would be something that would be determined at the time of the filing. The utilities would make a filing that would establish all of the amount that they need to recover if it is appropriate to offset that with late fees at the time. Parties and would have every opportunity to address that, and if the utility did not include it, would certainly follow up and find that out. By adding the language, it sort of implies that they are required, and that's a little bit of a tricky issue that may create some controversy. So we're just recommending that it be left without that language, because we don't think it harms any ability to, if applicable, use the late fees to offset those uncollected costs. But by adding it, it sort of implies that it has to be incorporated. That's why we just recommend it be left the way it was originally.
But, just so I understand, the utilities didn't make any comment about this one way or the other, right?
That is correct, I believe, Mr. Chair.
Commissioner Richard, so.
Yeah, just for staff, I mean, is there any harm just to being specific? I mean, isn't this a standard part of, sorry, a standard part of POR, purchase of receivables for in the retail space? So why wouldn't the administrative charge also not include it for CCA?
So, I mean, staff has, I think, traditionally taken the position that late fees are appropriate to offset costs for uncollected and other types of charges that are needed for the POR discount rates. So, you know, the concept itself is fine. We're just simply pointing out that by there may be other unnamed things that need to be added to this
And it's probably best just to require them to make the filing and leave the judgment as to whether or not this specific element would be included. If you add it, it sort of implies that, you've already sort of decided that that is an element that should be incorporated.
Okay,
And-
no, I understand that.
that's
It's
why.
been an element for as long as I've been here, so I'm just trying to understand why staff would object to it. It's a standard practice now for the most part.
I think
Is
it's-
it not?
It hopefully is and will continue to be recognized as a legitimate element of, for calculating the discount rates. It's just as a matter of practice, listing it as required, it may imply that, there may be reasons in this particular instance that those late fees might not be appropriate if there's some other need to exclude them. So I think it's, what we're simply trying to do here is like that with a number of things that are left to tariffs and things that have to be dealt with, you sort of indicate that it would be addressed by the commission later.
Got it. Does the county have any, I think right now your official position is no objection to the language.
Yeah, we had no objection to the language, we took the final position when we made our comments.
Okay.
Mr. Trout.
So I think we may have blinked on this when the comments were being filed, but we agree with staff. We agree that while there is a likelihood that late fees will be an element in the purchase of receivable calculations when the commission gets around to the purchase of receivables issues and when the tariffs are ultimately framed, we think hardwiring it into the regulations up front now constrains all of the parties, including the commission, from crafting the appropriate balance at the appropriate time with respect to this and related issues. And we also note, with respect to your point, Commissioner Richard, I agree with you about the history, but I also note that earlier today, Mr. Lapp explained why there is not a one-to-one congruence between the CCA and other retail suppliers, and the differences between the CCA and other retail suppliers will only become more obvious as we go along and as for example, the aggregation plan gets submitted to the commission. So we probably would be prudent to do what staff has recommended here. And Potomac Edison, I have not had a chance to consult with my colleagues, but Potomac Edison at least supports staff.
Do any of the other parties want to, actually, so let me start with Mr. Lapp and then I'll turn to.
Just real quickly, OPC would support staff's position on this as well.
Okay. Ms. Sikora.
Yes, the Exelon Joint Utilities support staff's position as well.
Okay. All right, I think we were going to go with staff's position, so.
All right, thank you, Mr. Chair. I know that's the only language that was contested for Chapter 18. I just want to give the Commission another opportunity to raise on its own any concerns or issues with the remainder of this language. Just of note, however, that the rest of the chapter is consensus.
I think we're fine.
Okay. So now we're moving on to, I believe it's the third issue on the agenda under moderate issues that relates directly to Chapter 11. Chapter 11 is that CCA aggregation plan requirements and application process. So, Commissioner Suchman, this relates to your earlier point about clarifying the CCA offers with respect to SOS. This is the relevant chapter. The material issue that is in dispute here let me just scroll through quickly. Bear with me. It relates to Regulation 3. However, there's a lot there's a lot in terms of language for Chapter 11. And in addition to that, the Retail Supplier Coalition did also raise a related issue that wasn't captured in and reflected in the proposed regulations that have to do with contract summaries and a contract summary requirement. So why don't we do this? We'll address the Chapter 3 dispute as it relates to the alternate proposals, and then after that, I will go back up to through the document to tee up the Retail Supplier Coalition's proposed contract summary requirement. So if I can direct your attention to Regulation 3. Regulation 3 concerns the aggregation plan approval process. Not only does this chapter enumerate the requirements for the actual proposed aggregation plan, but then also the approval process for the commission that covers not only the requirements for filing a proposed aggregation plan, but also touches on discovery by the parties, changes to the commission approved aggregation plan, and that's where we are. The county and staff propose alternate language for Regulation 3, paragraph D. And center on how changes to a commission approved aggregation plan should be handled. So let me bring this, and I do apologize for the small print right now. That is, the county has proposed, the county's language is in the comment bubble off to the side. So with regard, yeah, right. So we will.
New language. We've new language as written in our comments.
You have new language.
It's the language that we filed in the comments on July 7th.
Are you talking about D or
This
E,
table.
Joey?
We're talking about D right now.
D, the language in the body, is the county's language, according to the bubble from the, yeah.
That's true. That's right.
And
My
staff's
apologies.
proposed language is in the comments. I just wanted to clarify that.
Yes, my apologies. So what you see in the as filed language is the county's language, and then staff has proposed alternate language for D in the bubble to the side.
So, just to sort of be clear, are we going to be talking? Are you going to be going through the entire chapter and then we're going to be talking about issues, or do you want to take it one chunk at a time, which I would find easier?
One chunk at a time.
Okay. Thanks.
So, I want to focus the commission's attention just on section D. And I will yield to staff for if staff wants to make any comments on its alternative language.
Phil Vanderhayden, again on behalf of staff. So in section D, the distinction between what's in the, yeah, I think it's the same. I think we have slightly different versions. I'm not sure that edit is the same as what we've got, but I think for this it didn't change. So there's the difference is, if you look at D2, the way this is written in the text, it says the commission approves the aggregation plan and it includes the following items. And so terms of service, transition schedule, and the cybersecurity plan.
So I think the concern we had in the original way it was drafted was that we wanted very specifically that the commission approved the aggregation plan, the terms of service, which is the only part of the service that the commission is currently approving, since rates are not approved per the previous decisions of the commission. Terms of service and the transition schedule and the cybersecurity plan. So I think it might be relatively minor now. It's going to come down to how the aggregation plan is approved, but very specifically and in particular, the cybersecurity plan, staff was very concerned that that be not only approved but documented and consistent with the regulations in the proposed Chapter 16, but the transition schedule itself sort of would also have, with its specific timelines, be approved, and as well as the terms of service. So the aggregation plan, I think the distinction we've got is under D2 as written in the body. You're dealing with potentially a single order that approves the aggregation plan, and all of those three terms may or may not be explicitly approved, which sort of applies to what we're going to talk about in Section E, where we're looking for if any changes are made to the things that the commission approves in the aggregation plan, that they would come back in front of the commission for review. So I think a lot of 2 sort of hinges on what happens in what happened. D2 hinges a little bit on what's happening ultimately in Section E that addresses how material changes are made. But the distinction is that I think if you read the language in staff's recommended in the bubble, you have a specific order that's going to approve each one of those 4 items, rather than potentially just one order, which may or may not explicitly approve one of the A, B, and C. So that's, I think, what was our general concern. We see those components as being sort of the critical elements of the aggregation plan that require specific commission oversight.
So the county have a response.
Yeah, specifically, yes, Chair Hoover. The statute doesn't require approval of a cybersecurity plan, approval of a transition schedule. It describes what should be in the aggregation plan, and we've not objected to including a cybersecurity plan, but the idea that these things have to be separately and specifically approved before the CCA can commence, we think that's actually contrary to the statute.
So I'm going to turn to the parties here. Would it be better if because it seems that the majority of Section D up to 2 seem to be almost identical, if not identical, with the exception of the numbering. So if D2 is really what we're talking about, and it concerns changes, and it's related to the next section, Section E, would it be better if we just looked at Section E then?
Yeah, I'll be honest, the language in the comment for staff's proposed language at this point, I think, is so similar to the language in the body, I'm not sure what the desired difference would be. So yeah, maybe discussing E makes sense.
Would that work for the commission?
Before we leave that, can I just ask?
Yeah, all right, one question.
Okay, before we get to 2 or 3, whatever number you're looking. So I'm finding confusing. The commission issues 1 or more orders approving the county's aggregation plan. So then the problem is, what if the commission issued 5 orders? Which one do you look to? Do you look to the first or the second or the? It just seems to me that the commission is going to approve the aggregation plan, and if we're not going to approve all of it, then we're going to issue perhaps several orders until the plan is approved. And I mean, unless you're, so I'm just finding this, I'm finding the language confusing. I don't understand why it can't just be the commission approves the county's aggregation plan. Does that make sense?
We would support that.
Okay. And then, terms of service is not a defined term, and I'm a little concerned because, you know, we have taken ourselves out of making decisions about whether the rate is appropriate. So, I'm sort of opening this up to whether we should be defining terms of service, I guess as being everything else, but then I mean, I wasn't part of the commission when the commission made the decision not to look at whether the rate is appropriate, but the question for me is, you know, how far down does the commission look in terms of whether what's being offered to the ratepayers in Montgomery County is appropriate? And so I'm asking whether it's appropriate to define terms of service. I mean, I'm actually a little concerned about, I'm always really cautious when you have something that says including the following, because you can read that to mean that if you include stuff, then that excludes everything else. Or you could read it as it's including, but there could be other things as well. And so I'm a little concerned about putting all of this stuff in when previous to this section in the aggregation plan, it was pretty comprehensive about what needs to be in the aggregation plan. And it may be better from a drafting perspective to make sure all of this stuff is in the aggregation plan that the commission is going to approve, and then you don't have to worry about the issue about including and excluding. So I'm just sort of opening that up to discussion.
I think we would support, yeah, so you're suggesting that basically to say the commission issues, or the commission approves the aggregation plan and then period, and there's no itemized list, we would support that.
Commissioner Suchman, your view is consistent with the approach that we've been taking for quite a long time, actually.
Okay, so is there, staff, do you have a response, or any other parties think it's important to have this in, this sort of enumerated list? Enumerated list, especially when you've already got a sort of a detailed set of requirements for approving the aggregation plan, to the extent you leave anything out here, it's going to suggest that it wasn't important in what was being proposed in the aggregation plan earlier in the regulations.
Commissioner, if I could maybe attempt an answer to that. So in this, I think we agree that there's a little bit of a question as to whether or not you include a number of items. So I think the proposed language that staff has, we identified the elements that we thought were critical for the commission to specifically approve in order to start the CCA. So we're suggesting that those should be identified and approved individually. I think our concern by just blanket approving the aggregation plan is at this point we don't precisely know what information will be provided, or perhaps the level of detail that will be provided. You know, for example, if there's terms of service that don't describe all of the terms of service but approach it in a general fashion, the commission could approve such a thing, and then, you know, perhaps the point at which a rate changes was not incorporated within the terms of service, and so customers are perhaps surprised by that. If you have a situation where we have a transition schedule that has a specific, like, identification of the dates at which the various elements of starting the CCA, the transitioning of customers, that sort of thing, if that is sort of generally described without the specifics, there may be some flexibility that is perhaps helpful to the CCA, but maybe impacts other customer groups or creates uncertainty, in particular in the area of acquiring and providing SOS to customers that opt out. So staff laid out the specific, going through all of the elements that we thought would be required to be in the aggregation plan, identified the 3 or 4 things that are specific that we wanted an order to describe a specific document that laid out those details in particular.
The problem with that is that then you're suggesting that everything else that was detailed in the aggregation plan is not all that important. And if staff thinks that these provisions should be highlighted, then you can put in the aggregation plan, at a minimum, the following is required to be in the plan. I just think it's going to be confusing, and I think it would, if I were working for the county, I would find it confusing that I'd have these requirements in the aggregation plan section, and then you have this provision about approval that contains some elements and not others. And so if staff thinks that there are elements that have to be in the plan, and I'm not making judgments about whether that's right or not. This is more of just a process issue. If you think that these are important elements that must be in a plan, I think it just makes more sense to put it in the aggregation section, in the aggregation plan section, so that, whatever the county is presenting, at a minimum, these elements have to be in. Does that take care of your concern?
If I may, I think we are looking at the aggregation plan regulations that are in this chapter as generally as a set of filing requirements that sort of in total list all of the elements that are sort of giving a heads up to the counties, like you need to have all of these things in here. There are several other chapters that go and explain specifically how the commission will review some of those elements, like the cybersecurity plan or the purchasing plan and things of that nature. So by citing these specific things, these were in particular the things we thought that had the most impact on perhaps the way that establishing the CCA will affect not only the utilities but the customers that remain on SOS, the provision of SOS for the remaining customers and that sort of thing.
Right, and I think it could be sort of maybe earlier in this chapter. I found it confusing, that you had the elements of an aggregation plan, and then you had this review that only contained some pieces of it. It was just from a process perspective. I found it confusing. I think it could be cleaner if you have the elements of the plan. This is what's required, and so when we're looking at the plan, we know what is important to the parties, and then understand that the rest of it is important but not as important. So you have sort of priorities of importance. If that's what you're saying, that there are sort of priorities of importance.
I think all of the elements that are in the filing requirements are important. There are just specific things that we were looking to have very clearly approved or accepted by the commission. So it's more, I think our approach here is like both of these will work. I think we're proposing something that we thought made it sort of some advance notice of how we're going to go about managing the process of approving the aggregation plan.
I guess if you are, I guess one way you can look at it is that you're kind of tying our hands. You can flip the way that this is written to say the commission shall not approve an aggregation plan. I'm not recommending that you do that because I don't really want our hands tied. But if that's what you're sort of suggesting, that we should not approve a particular aggregation plan unless the following elements are in it. If that's what you're sort of suggesting in your comments.
So the use of Chapter 11 as a sort of a set of filing requirements wouldn't bind the commission from approving the aggregation plan if something weren't in it, but it would certainly give a heads up to whoever's making that filing that certain elements should be incorporated, and that if they're not, that someone might raise the question. Staff is almost never going to
agree to anything that we would consider binding the commission's hands.
Thank you.
Going forward.
Right.
So, again, I think our approach here was trying to figure out, with the limited information that we had and still have, how this is all going to work, what would be the best way to make sure what we saw as very important elements to be considered and incorporated. This is not, I think, the most important element of this particular chapter that's still under dispute. The following section E certainly very much is. So I think either way will work. I think we were looking for something very specific so that it makes it easier to identify the elements, but if folks are not comfortable with it, then this is not where we would recommend you absolutely, choose one side or the other.
Any other commissioners have any questions? Commissioner O'Donnell, you have a question?
Thank you, Mr. Chairman. I had questions around the commission approval as well, and I know I had some deep questions. Well, I thought they were deep. The last time we went through this, in terms of what culpability is the commission buying on approval? Now, we had County Executive Elrich come in and talk about owning this program lock, stock, and barrel with full accountability. But then in subsequent sessions, I heard some backpedaling on behalf of the county in that regard, which concerned me greatly. And someone needs to answer for me what approval of this aggregation plan connotes with respect to the culpability of the commission. For instance, are we going to hear, well, you approved it. Hey, it don't work, but you approved it. Because if we hear that, then this whole thing is going to come apart at the seams. And so maybe staff and then the county and any other parties that wish to opine can talk to me about this. And if you recall, try to pick it up where we left it as an unresolved matter the last time, if I recall, if my memory is serving me correctly.
Commissioner O'Donnell, I will attempt for staff to answer the question as to sort of the commission's, by approving the aggregation plan. I mean, the commission is sort of being tasked with approving this plan. The law has been interpreted by the commission such that the actual rates for the default service that customers will take, those are not being approved by the commission, although the commission has made that decision to interpret the law in that regard. The remaining elements that are in the same section where it talks about approving the rates are terms of service. There are some other elements in there. The commission I believe, should be looking at this as if it's approving something like a tariff, potentially this in the same manner where the commission allows an SOS rate to go forward. The commission is exercising its jurisdiction to interpret the law to allow this CCA to go forward, and you're using this public record and all of the various the knowledge of the stakeholders to come up with the best approach to it. So ultimately, it may be difficult or impossible to avoid if there is a negative outcome and someone points at the commission. But at the same time, you've been given many statements from various parties encouraging the maximum flexibility, and I think the commission has done the best to sort of weave through all of that.
Well, let me be more specific. I think we were maybe it was implied that we could and should and maybe asked to approve an aggregation plan that didn't detail a procurement process. We do that, and then we get a procurement process where Uncle Jimmy and my brother's cousin is getting supply contracts, what have we bought into by approving this thing without such information? And we were told, I believe, that we may not get such information prior to approval. Because we need approval. It was a chicken or egg kind of discussion. We need approval of a plan before we can proceed to work out those details. But how do you approve a plan if you don't know those details?
Your Honor, I think you can only act on the information that's in the record in front of you.
Well, that doesn't make me feel good, sir.
If I could jump
That's
in.
why I'm asking questions now, so I don't have to deal with it later.
Well, actually, before I turn to you, did the county have a response to both Commissioner O'Donnell's questions and what staff said? So, and then I'll.
I do, and actually it also dovetails on what Commissioner Suchman
Sure.
was asking
Right, right.
earlier, if
Yeah,
I may.
yeah. So.
In section 2 of this chapter, it lays out the aggregation plan requirements and what we have to include in the aggregation plan. And I think this directly responds to what Commissioner Suchman was saying earlier, and I believe it also addresses some of Commissioner O'Donnell's issues. This goes on for 19 items, not including sub-items and sub-items. It includes under 2B2, the proposed CCA transition schedule. Under 8, a description of the purchasing plan, including the proposed plan for procuring supply and supplier evaluation criteria. I won't read this into the record, but it also includes in 15 the proposed cybersecurity plan. I believe that that I would argue, there's the arriving at these items was no mean feat, but there are, as I said, 19 separate things, including all the subsections that have to be included. All that goes to the commission having the information it needs to approve the plan, and it is in our best interest to make sure you have all the information necessary to approve the plan.
Of course it is, but get to my chicken or egg question. How do you do a procurement or a purchasing plan unless you have an approved aggregation plan? But yet, how do you get an approved aggregation plan unless you have a purchasing or procurement plan?
And that's an issue we've been struggling with. That's why we tried to lay out the timing of filing the coordination tariff, and all the items in this list. We think we have hopefully gotten to a place where the chicken and egg will be in the proper order.
Well, what is that order? That's what I'm asking.
We will lay out all of this information, including where was I at? 8. The description of the purchasing plan and the proposed plan for procuring the supply. And we believe that will allow the commission to make their decision on approving the aggregation plan, which will then allow us to go forward with actually, because that's the actual trigger for a county as a community choice aggregator after submitting. It's only 3 things: submitting the notice of intent and aggregation plan required, the commission's approved the aggregation plan and the proposed terms filed in accordance with paragraph 1B, and enacting a local law. It's 3 things that we need.
Well, I still have a little bit of indigestion here, Mr. Chairman, in this regard, and the county didn't put its best foot forward the last time it was in to see us on this particular matter, in my opinion. In fact, became argumentative with this commissioner, which is never really advisable unless indicated. I'll let it go for now, but I got questions. Thank you, Mr. Chairman.
So, Mr. Lapp,
Yeah, just real quick. I mean, I think it's our position that we should be looking to the statute for guidance. The statute says a purchasing plan designed to save ratepayers money. That doesn't mean the commission has to find that the plan is guaranteed to save money. It just has to have findings of fact and make a reasonable determination that the county's plan is designed to do that. And nobody can predict what's going to happen in the markets. And so, a guarantee is impossible to make. And ultimately,
Hey, hang on. Can I stop you right there? I'm not asking for a guarantee. I'm asking some fundamental questions. I'm asking some fundamental questions about which comes first. Not a guarantee about perfection. That's not what I'm asking for. So if those words are intended for my characterization, they're not even close to the mark.
and I guess, and I would just say, ultimately, the success of the program does not depend on the commission. The commission needs to perform what's there in the statute, make its determinations as to the aggregation plan, but the ultimate success of the program is with the county. And I think that in thinking about the aggregation plan and compliance with the statute, the commission should also think about not unnecessarily inconsistent with the policies that are attempted to be advanced by the General Assembly in passing the statute of tying the county's hands so that its chances of success are less. So I think that's an important consideration to keep in mind as well, but ultimately it's the county that succeeds in the program or not.
I'm of the opinion that if a process was laid out that said, here's how you jumpstart this thing and get it rolling, and then here's how you approve an ultimate aggregation plan subsequent to that jumpstart, it would have been a whole lot easier. But we're going from approval of a plan from jump, and I'm just joking on that a little bit. I'm sorry.
I just wanted to comment on Commissioner Suchman's points earlier. We would agree that approach of not adding a list of items that are included, it would be preferable, would be a better approach, because you don't know what's going to come up. It's going to come up in the context of the aggregation plan. The statute at E14 says proposed terms of service, rates, and categories of charges, fees, and or other costs to consumers unrelated to the actual cost of the electricity supply. Those are other elements that are not in the list, and I think could become an important part of the evaluation. And so, pulling specific items out, we would agree, and listing those in the regulation is not a good idea. So, thank you.
Any other commissioners?
Mr. Chairman?
Actually,
I actually wanted to follow up on Commissioner O'Donnell's inquiry, because I'm having similar concerns, but I think it can be addressed if we think about the fact that the county, on some level, is kind of substituting itself for the utility. I mean, you're not a utility, but you are going to be providing service in the way that the utility provides SOS service. You're just going to be doing it differently, and we have determined, way back that when a utility procures power in the marketplace, it requires credit, letters of credit, and this is to protect itself and to protect its ratepayers. Something goes south, and you want that. You want the guardrails, and you're doing a new program. This is a pilot program, and so you don't know what's going to happen. I mean, we've seen how it's worked in other states, and they've been mostly successes, but there have been some problems, and I've spent this weekend looking at some of the problems in New York, and so we're at a new territory, and I know that there's a whole list of things here, but it just seems to me that if we don't have some guardrails that protect the county if the supplier goes south on the one hand, and then if you are forced to migrate all of the ratepayers in Montgomery County onto SOS, and there is language in here that protects the utility, but there isn't anything there that protects the ratepayers if they're sort of moving over. And it just seems to me that I'll have a whole lot less heartburn. And I don't know if Commissioner O'Donnell will have less heartburn as well. He can speak to that. But I would have less heartburn if there was something in here that required that there be an instrument in the preparation of the aggregation plan, letter of credit, guarantee, whatever, that protects both the county and the ratepayers in the county. Then I feel a whole lot better.
Commissioner Suchman, these are excellent questions, and these are absolutely topics that the work group has spent a lot of time discussing. We at the county have spent a lot of time independent from the work group, as well as engaging with their work group on these topics. We're highly aware of the different approaches, the different attributes to look for in a supplier, approaches that other CCAs have taken, which have resulted in the type of outcome that you just described, but that are different from the approach that we're going to be taking. These are issues that we're going to be discussing at length in the aggregation plan. We're aware that they're of critical importance to our residents, our customers, staff.
I'd like to see it in the regs, because if you put it in the regulations, then the ratepayers of Montgomery County can see, oh, they've got something in there that's going to protect me. I'm going to feel a whole lot better about not opting out, because I know, it may be that I'll be paying a little bit more than SOS, but I'm not going to be paying a whole lot more than SOS, and that's going to make all of the ratepayers in Montgomery County feel better.
So we are acutely aware of those different factors, and so in the regulations, it does describe 4 critical issues that we'll be looking for. The heading is supplier evaluation criteria. So these are some of the criteria that the county will be looking to.
Yeah, no, I saw that.
Okay.
Just, if you could just put in there an obligation that there be an instrument. You don't have to identify what the instrument is, but its intent. The instrument intended to protect the county and its ratepayers, because you have it in a different, I guess we're going to talk about it later, in a different section of the regulations, proposed regulations, saying that you're not going to impose stranded cost on the utility.
Correct.
But you also don't want to impose stranded costs, or whatever we call them, on the ratepayers. That's going to be very bad for everybody.
So I think what you're getting to is creditworthiness. That's the term that you mentioned a moment ago. Creditworthiness is a required evaluation criteria that we'll look to in contracting with a supplier.
Yeah,
Would this meet your requirement?
If you can just add some additional language, including an instrument that will protect ratepayers and the county. Something that when you look at it, you'll understand what that means, and will understand what that means.
So if we take this as a note and put this in our plan, would that meet your requirement, or do you want this specific requirement in the regulations themselves?
Why don't you propose some language? And you've heard my concerns, you've heard Commissioner O'Donnell's concerns, and he may want to respond as well. But I'd like to see what it is, and I'd like to hear from other parties to see if that is something that is either of concern to them, or they don't have an issue with adding the additional language.
So we're certainly, we will take this under advisement and maybe get back after the break with proposed language.
That would be
on
great. Thank you.
provision in this area of supplier evaluation criteria. Getting back to the section at hand, they were talking about in terms of the orders and the naming of the documents requiring approval. I just want to bring us back to that topic, unless you want to talk more about this individual requirements.
I was just picking up on Commissioner O'Donnell's concerns,
Got
and
it.
so I didn't want to lose that because I agree with him as well.
Yes, understood.
And I will just say, such an instrumentality may go a long way towards requiring the fulfillment of the promise made by the county executive when he came in and explained the county's ultimate aims in implementing this and its culpability for A to Z therein. So it may be helpful to head in that direction. I'm not in disagreement with the suggestion, Commissioner, at all.
Any other commissioners? Commissioner Barbe.
Yeah, I'd like to talk about a different topic if that's appropriate at this point. I think earlier in this chapter there are some mentions of notice to prospective enrollees and education, and now forgive me because this is written different from how legislation is written, so maybe I didn't get quite everything, but it appears to me that the notification to ratepayers, there will be either one or two notifications and opportunities for the ratepayers to either opt out or purchase another plan. There is a notification in a newspaper of record, which the legislature insists upon putting into bills, even though we know that that's completely worthless. I won't go into why we do it, but who wants to anger the editorial board of the Washington Post prior to an election? And then there is the reference, I think, of going onto the county's website, which, after 32 years of representing the county, I've personally never done that. So my first baseline question is, how many direct notifications are being given to enrollees? And did you and the work group or did anybody in staff look at what the practice was in the states where this has succeeded? So
Actually, before we get to that, though, is this a topic that's going to come up specifically on its own later, or is now the time to do this?
There is a reference in Chapter 4. I'd be happy to put off my question until we get there.
Joey, from your sort of process thing, I mean.
So the aggregation plan does include requirements of how the CCA is going to be handling notices to customers.
Right.
Later on, there is an issue specifically covering, material disputes around the opt-out notice. So, Commissioner, I think it's perfectly appropriate if the Commission wants to sort of talk at a high level of how the CCA plans on talking about notices, and then if there are decisions to be made, we can then jot those down and then kind of apply them when we get to the opt-out notice if there is some overlap there.
All right. So, given that, is the county prepared to respond to Commissioner Barbe's concerns regarding how you're going to do the first notice? I guess is what we're talking about.
I will certainly try to clear that up. And yes, it does apply to sort of multiple chapters.
Sure,
but
sure.
I'll start with the statute. So the statute lays out a very clear information process. 60 days before initiating the process to form a CCA, the county's got to develop the plan, give written notice of the plan to each residential and small commercial electric customer in the county, put it in the paper, all that stuff. And then, so there's a whole bunch of stuff that happens like before you even see the aggregation plan as it's been drafted. And then, once that's been approved, there's a whole separate process for that we're referring to as the formation notice, just sort of we had to come up with something. We're calling that the formation notice, and then after that initial phase, we send a separate notice. So we call it the opt-out notice, and this is in accordance with the schedule established by the commission. So if the commission we can discuss timing of it. But basically, we send the notice that has a very clear list of things that have to be included, including exactly how the customer can choose to opt out. And there's going to be there are multiple avenues. So.
Well, how many times, though? I mean, and the reason I ask it is that my cell phone carrier had to bug me 4 times before I changed my payment from my credit card to my bank account. And if I had not received a notice saying we're about to discontinue you if you don't do this, I wouldn't have cell coverage right now. And they had to bug me 4 times, and I'm a relatively, I think of myself as an accountant. I think of myself as being a person who's good at responding to things. But we live in a world where we are badgered dozens of times an hour on the internet, in the mailbox, and the response of most of us is to throw that stuff away. I mean, when I open up my Pepco bill, I pull out the bill to find out how much I owe them, and then I rip everything else in half and toss it in the recycle bin. I cannot remember the last time I looked at a notice that was included in an electric bill. So I'm very concerned that the ratepayers of Montgomery County have more than 1 or 2 opportunities to say, I don't want to enroll, or I do want to enroll, before they're automatically enrolled.
Okay, so I will point out that there's an ongoing process. They can choose to opt out even if they've been enrolled in the CCA. They can choose to opt out by going back to SOS or choosing a retail supplier after the fact. But I hear what you're saying about the time period. That ties in actually to one of the things the county does very well is communicate with its constituents. And I'll let Mr. Edwards go into detail because he deals with more of the programming side of the world. But we anticipate a very robust information campaign. So we don't want consumers to be surprised. We don't want any of these folks to be surprised that this happens. So, they will get an initial notice. There will be information out there. They will have this opportunity to opt out before we do the transition, but they will continue to have that opportunity to opt out. So we think that between the way the statute was written and what we've tried to put in place, that, again, we want customers to be educated and to be informed. It's to their best interest and to our best interest.
And as you also, another thing I'd like to know is if the work group or if anybody here looked at what the best practices were in other states, how many notifications were made. I'm curious to know if that's been looked at.
Well, the dates for notice, as Ms. Brennan mentioned, were established in the statute. So the minimum notice is established in the statute. Also, as Stan can talk about, we'll have a robust campaign. Customarily, communities welcome CCAs. And so they're not seen as being imposed on them. They're seen as benefits being brought to the community, particularly when the price is at or below what they're paying today on standard offer service.
If I could just add, it's interesting, we started this about procurement, and now we're talking about customer notification. Those two things are inextricably linked as far as I am concerned, because if we can develop a procurement process and a plan that doesn't result in a customer seeing an increase in their electric bill, I'm not saying that notification is not important, but my assumption is people would be less uncomfortable, if I can use that term, about the advent of the CCA. So these two things are very closely tied together. It's certainly, I'm not going to sit here and say that every resident of Montgomery County gets every notice about everything that the county does. We know that's not true. And we will make every effort to make sure they get clear notification. But as Ms. Brennan points out, they will have the opportunity to opt out at any time. We will continue to provide notification in a variety of different ways. The county has lots of tools, as organizations do, to communicate, whether it's social media, direct mail, newsletters, electronic newsletters of all types. But these two issues about making sure that we are able to do a procurement process in a way that makes sure that rates are stable, are following SOS as closely as possible, I think will minimize the concern people have.
Well, as I said, I supported this legislation. I believe in what's being attempted here. I would hate for an instance to occur where a large number of people feel they were enrolled against their wishes. I want for this CCA to be a model for the state of Maryland. I don't want for it to be a cautionary tale. That's my concern. And Mr. Chairman, I think I have to think more about this before I want to vote on this, on what's incorporated in Chapter 11. Is it Regulation 11 or Chapter 11? Because I hear what you're saying, but I'm very concerned that good service to customers, good customer service is adequate notice, because there will be a lot of people who, we have to make it so that there are not a lot of people who get enrolled and then discover that their rates are like slightly higher. You would be amazed at how annoyed people become when there's even a teeny increase in a rate. So.
One of the things I do in the county is enforce the county's, I have a team that enforces the county's environmental regs, so there's no surprises to me about what residents would be interested and concerned about. We're really sensitive to what you're saying.
So following up from Commissioner Barve, who has raised, I think, really important issues, remembering that this is a pilot program, so that what you're doing is going to speak to other counties who might be interested in this. Would you have a problem with adding some language into the regulation to require in your aggregation plan sort of robust reporting and robust communication, so that the commission can look to what you're doing and can weigh in on whether we think there needs to be more engagement with the community?
And let me add one other thing. Again, this is all in the guise of consumer rights. I would love to see what the notice. I would love to know how the notice is going out. I would love to be able to see these notices, to see what I and my wife are going to get in the mail and how it's going to look, because I really want to be assured that there will be, as I often said in my committee, I tried to make environment and transportation into a no-surprise zone, and that's what I'd really like to do with respect to the CCA.
Commissioner Barva, you asked if we looked at other CCAs, and we have. And we know that in other CCAs, it's also customary to include a copy of the type of notice that you're suggesting. So it has long been our plan to include that very information, and we certainly will be and welcome the opportunity to share with you all the details in which we're going to be conducting this robust informational campaign, because it's something that the county has been working on for years through the Climate Action Plan. It's something that the county is extremely proud of and wants to engage customers with. So we consider this to be, a great opportunity to wave the flag, not to hide or, keep people in the dark about anything.
Right, and let me also say that having, represented the county and at least Rockville and Gaithersburg for 32 years, I know that there are people who will pay a little extra for only green energy. I know those people exist. My wife and I, or probably people like that. But I think that people have to feel a comfort level that they've been asked appropriately, and that it's not a surprise to them.
So I don't want to get off topic, but I do want to respond to your question, and a topic that's come up in other questions also in the last few minutes. The full expectation is that when the CCA commences delivering power, the price is going to be at or below SOS. Sure. That's the full CCAs don't operate; they don't work well otherwise. And so that is a theme that underpins countless issues, that are before you today.
I think the other thing I would say is that CCAs typically offer you choices about what you want, and there are going to be residents who want to pay more for 100% clean energy, for example. And I anticipate the county would offer that kind of option.
So just to be clear, though, after the break, you'll give us some language that can be added to the section to require that notification proposals will be included in the aggregation plan, so that we can see what you're doing and can weigh in on whether we think it's not enough.
Sure. Can I just ask, just for clarification purposes, In Chapter 11, under Section 2, numbers 3 and 4 detail the processes for participation, including, sort of how customers are going to be enrolled and processes they'll have to decline and other things. And then under 4, the circumstances and processes by which the CCA will provide notices, including the draft notice as requested by Commissioner Barve. The purpose of the notice, actions taken by the CCA in response. So I will be happy to edit that if you think that there's something missing, but I guess I'm
Why
not
don't you,
sure what would be.
Commissioner Barve noted that Chapter 4 also deals with notice. So it may be that may be the more appropriate place, or maybe we need to do it in both sections. But I think you understand his concern about making sure that the ratepayers of Montgomery County get sufficient and effective notice, so that they know what it is that they're not opting out of. because they're not going to be opting in, they're going to be not opting out. And so we're just concerned that when they make the decision not to do something, it's based on information that they've received from you over maybe a year, and in multiple venues.
Absolutely. And like I said, I was just trying to, for clarity purposes, I just wanted to know if there was anything in particular you thought was missing from 3 and 4 in the aggregation plan section. We have the draft notices, the purposes of the notice, the actions the CCA is going to take in response to those notices.
I don't, because as I said, I'm just not familiar with this style of draft writing, so I'm not as up to speed as I will be in a month or so.
Understood.
How shall I say?
Understood.
All right. So bring us back to where we started. Where are we related to this discussion about the terms of service, transition schedule, and the cybersecurity plan? So, I mean, my understanding from what staff described, they mentioned it as being sort of minimum filing requirements, and I guess that kind of triggered in my mind, are you talking about the circumstances like when a utility files for a rate increase, that there's certain things that they must include in that? Are you insinuating that that's what you want for this aggregation plan?
Yes, Mr. Chair. The Chapter 11 is detailing all of the items that we believe should be incorporated. Sort of like filing requirements would say you must have this, 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 and this.
Okay.
In order to sort of make it clear what elements, need to be specifically identified, addressed, explained, or otherwise.
And the county's response to that?
We had agreed with Commissioner Suchman's proposal that D2 read, the commission approves the aggregation plan. So we actually agree that we think the itemized list is problematic. We had agreed to this language, but I previously, but in light of the discussion, I would agree with Commissioner Suchman that basically the itemization is actually more problematic than helpful, potentially, and that it should just end at, to the commission approves the aggregation plan.
Any thoughts from?
No, I'm good for right now.
No, I'm in agreement with.
So, Commissioners, the proposal on the table right now is to modify the county's language per discussion to now read D2, sorry, that's not intended to be crossed out. The commission approves. So, in other words, going back to 1, context is county may not begin providing CCA service until the following has occurred. A, or that the commission approves the county's aggregation plan. We'll put that semicolon. And then the county has enacted a local law. So that third provision down there that you see, that's going to remain intact.
If we could just so that it matches has, so the commission has approved, and then the county has enacted. Otherwise, you have
Done. Okay.
You understand what I'm.
Okay, and,
Yeah.
okay, that's what we'll do. All right.
All right. Keeping an eye on the time, the issue of material changes may involve a little bit of discussion. So, Mr. Chairman,
Okay.
Mr. Chair, we can proceed.
12:15, so I guess we'll come back at 1:15? Does that work?
You're the boss.
All right, okay. We're adjourned till 1.
David, can you hear me?
Commissioner O'Donnell, because Dave checked his mic. Dave remembers like where things are in the rest of the document, so.
Mic check, 1, 2, mic check.
Okay, we're back on the record. Mr. Chen.
Great. Thank you, Mr. Chair. So we are in Chapter 11, continuing the discussion. Over the break, I understand that the county did take back and the comments and worked on the dialogue that they had with the bench, came up with some language to try to address not only the, or to at least answer the questions raised by Commissioners Suchman, Commissioner O'Donnell, and Commissioner Barbe. Before we hit the next issue, and just to be clear, there are 2 remaining issues or sub-issues in this Chapter 11. But before we hit that, I don't know if you wanted to provide the Commission with an update, Ms. Brennan?
Thanks. Sure. So I will address the questions about the notice and information to the customers, and then I think Mr. Krautheimer will address the creditworthiness question. So I just wanted to, and I apologize that I didn't have these before the break. Sometimes, there's 19 different, as I said, subsections in here, and sometimes I can't put my fingers on the first, on everything simultaneously. So I just want to point out that there's a couple things that I think are responsive to Commissioner Barbe's concerns. Aside from the provisions that I had pointed out for earlier in Chapter 11 under Section 2, B as in boy, 3, it's got a description of the processes and explaining things about the processes for customers to choose to participate and to opt out and such. And then in 4, we have the circumstances and processes by which the CCA will provide notices to customers, including the draft notices. I will mention that the formation notice will have gone out first, so we will provide a copy of the notice that went out, and then the draft notice would be the opt-out notice. The purpose of the notice and the actions taken by the CCA in response to the customer's response to the notice. But I think most responsive to what you were asking for earlier, Commissioner Barbe, I hope, is number 18. So it's towards the bottom of that section.
I'm having difficulty finding. Is it number?
Can I give you page numbers? Would that be helpful?
Maybe, yeah. Yeah, sure.
So 3 and 4 are on page 2 of at least my printout. Joey, if you, I'm not positive. I think they're numbered the same. There you go. So at the top of that page, Joey. Thank you. So that's the details and circumstances and processes.
Okay, I see that, details.
participation.
Okay.
And then further down that page on item 4. Thank you. The circumstances and processes by which the CCA will provide notices to customers, including the draft notices. As I said, the formation notice will have gone out before we file the aggregation plan, so that would be the actual notice that went. The purpose of the notice, and then actions taken by the CCA in response to the customer's responses. And then flipping way further down, page 7, number 18, if you might. Yeah, thank you. Excellent. Thank you. Right there. Are you there, Commissioner Barbe? So
yes,
we have
I'm there. So how many notices am I going to get in Rockville, Maryland?
You're going to get 2 written notices. That's what the statute lays out. And,
Okay.
these are expensive, so we're trying to balance. We want customers to be fully aware.
Right.
But we have, and we also are aware that not everybody reads their physical mail.
Right.
So we have the process that's laid out in the statute to send the formation notice and the opt-out notice. We have then a communications campaign that we will describe to you in the aggregation plan. And
So who's sending out the notices? Is it Montgomery County, or is it inserted into a bill from Pepco, or how's it gonna? Is it gonna be like a
it's the county or the
county, and
yeah.
it's gonna be like a postcard or a letter, or?
It's going to be pretty robust. robust, especially the opt-out notice. I mean, both of them have a lot of information in it, and I would also reference.
Well, one of the reasons I want to see this before it gets implemented, or rather, I think the commission should see it before it gets implemented, is if there's one thing I know about, it's direct mail, and if you put it in an envelope, it won't get read.
That's a challenge because the statute requires it. So, you know, we have this.
In an envelope or just mailed?
So it says, the county, so for the opt-out notice, the county shall provide or cause its selected electricity supplier, if any, to provide written notice of the formation of the CCA to all residential and small commercial customers. And then there's a list of what it needs to include that is
Voluminous.
fairly specific. Yeah, it's fairly long. So I don't think we're going to get, I don't think that's a postcard. Now, the response may be a postcard. You know, to opt out, do this, or to.
Boy, I just throw that stuff away.
I'm not sure how to get around the statutory requirement that we actually.
Well, you can have one envelope that's a big fat envelope. That doesn't mean you can't have two postcards also.
Yeah, I'm not sure. Like I was describing earlier, you know, the county's got lots of different ways that they reach out to its community. So, you know, we may decide multiple postcards. We may decide postcards and a radio campaign. We may decide, like, there's lots and lots of different. There's social media. There's lots of different options. The things that are in it are the things that are going to be in the opt-out notice are actually in another chapter. So we're going to get there, but I don't want to.
All right.
Not
Well,
trying
that
to
look.
distract you from this conversation.
Well,
but-
I don't want to slow the commission down unnecessarily. I'm just, you know, I do not want for hundreds or thousands of people to discover that they were enrolled against their will, because that will, I mean, it won't kill the program in Montgomery County. It'll kill the program elsewhere in the state of Maryland, and I don't want for that to be an unintended consequence.
We absolutely do not want that to be the unintended consequences as well. We are aware of, you know, the need to get the word out early and often.
Yeah. Oh, and by the way, my friend at the Washington Post still hasn't got back to me on how you would get a notice from your Washington Post app, which is where I think how most people read the Post.
Okay, so I hear what you're saying, and that's great. I guess what we're asking is that it just be reflected in the regulations. So if we go to 18, if you were to add the proposed process for CCA outreach and education, and then you can have a clause, something like, which shall be robust and comprehensive. Something that sort of says that in the plan, in the aggregation plan, you're going to have a robust and comprehensive listing of all of your outreach and education. And Commissioner Barvey, do you think that's getting a little bit?
Yeah,
closer to-
I think it does, but I would still like to have the commission review the document that's going to the ratepayers.
Right. And then I have one more place where you can add a little bit of language. So if you go to B, preliminary requirements, included in its petition proof of the following. And so there, it can be in the aggregation plan, but you could also have, you know, a separate document that just kind of lays out. I think it's really okay because it's a pilot program to have belts and suspenders. So you can have the outreach in the aggregation plan, and you can also have it as part of the petition. This is what we're going to do, and I'm just sort of offering it as sort of a suggestion of other places where it can be. I think it's better particularly on the education piece to go a little bit over what you would normally put into regulations, recognizing that this is a pilot, and also recognizing that you're going to be reaching out to a lot of unsophisticated consumers that are really going to have their hand held. And so anytime there's an opportunity to add some more language, and then it gives us as commissioners the ability to review that, because we're not just reviewing it for Montgomery County, we're reviewing it really for every other county in the state.
So, I mean, as we've discussed a couple of times so far today, the county has very extensive means of communication through many different channels, digital, print, mass media. multiple languages, of course. This is a high-profile undertaking of the county, years in the making. We look at best practices from other jurisdictions, so our interests are completely aligned with yours. We certainly don't want people to be surprised either. One thought on using words like robust in the regulations is that it's a little hard to quantify.
Right, no, I just threw it out. I mean, but all I'm suggesting to you is it's a comfort level.
Sure.
And so people reading the regulations are gonna hopefully gain comfort in the program if they know that there's gonna be a lot of outreach, and not just because you're telling us, but because it's in the regulations.
So after these regulations are promulgated, we will be reading these in like a few weeks, hopefully. This isn't going to be a very long time. And then we're going to begin the process of putting pen to paper and like writing the text that we're going to be submitting to you in a relatively short period of time. So we are hearing the feedback, which is fully consistent with our plans already anyway. It's now been made abundantly clear, again, not inconsistent with our intentions, to provide information about details about the robustness of what the campaign's going to look
No,
like.
I think we both understand each other. It really is just a language thing.
Okay.
It's just going to give, and not just people in this room, but others reading the regulation is going to give them some comfort to know that you're not going to just be sending people notices and putting notices in the Washington Post.
Right.
So if you can just take back from what we're saying, find a happy home for it, but put it somewhere where it's part of the review process, and it gives us the ability to review your proposals to make sure that they are robust enough.
How about
So is this your proposed language is in 18, which shall be robust and comprehensive?
Right, but you didn't like the word robust. And it really can just be, it just has to signal.
Detailed and
detail? What about which
Okay.
including details on?
Yeah.
Like if we took out the red text, proposed process for CCA outreach and education, including either specifics on or details on or detailing proposed. How about including?
Well, except I want to go a little bit further.
Yeah.
I don't want the language to just say you have to tell us what you're doing. You have to tell us what you're doing, and we want it to be comprehensive. That's the difference. You see what I'm saying? I mean, this literally just says, just tell us what you're going to do. And it could be like we're just going to send an email to somebody, or we could have a 2-year process. I'd like there to be language here that says it's not just that we're going to tell you what we're doing, but we're going to tell you what we're doing, and what we're doing is going to be comprehensive, and it's going to be sufficient to communicate to everybody that we need to communicate to. Do you understand what I'm saying?
I do, and I also just want to reiterate that, it is. We understand that you won't approve it if it's not detailed and comprehensive and robust. So that's the other. But I understand what you're trying to say.
Right. Because and remember, it's a pilot, so it's
Right.
really not just for you. It's
Right.
for.
Might I suggest the proposed process for a comprehensive CCA outreach and education?
Or effective? What effective?
I like both, comprehensive and effective. Because it actually says two different things. It's broad, and it's focused. So I actually like both of those.
You like detailed?
Well, detailed is not, and it could be little tiny detail. Comprehensive is broad, and effective is getting to where you.
I think that
Okay.
works. So.
Comprehensive and effective
Yep.
CCA outreach and education?
Yeah.
Okay.
I like that.
If it's going to be A, then it probably needs to be campaign or program or
Effective
something.
Outreach and education. Outreach and education is too
Okay.
far.
All right. I would take out the A, process 4.
Oh yeah, right. Take out
A.
it's just for comprehensive. Yeah.
Yeah.
Yeah. Yeah. There you go. Okay.
does that?
Yeah, I think that does.
We have no problem with that.
Yeah, I think we're fine with that.
Okay,
Terrific.
terrific.
Okay.
Could I just jump in? I just want to make a brief observation. We're fully supportive of these efforts to have, comprehensive, effective, and lots of consumer education. And this comment is just really an observation that right now utility customers are automatically defaulted in the default service when we have retail competition, and there's really no notice provisions. There's no requirements that utility customers be informed that they have retail choice options there, and there's really no notice that they are going to be defaulted in the default SOS service. Now, that service is rate regulated by the commission, so there's an important distinction there. But it's just something to keep in mind that there's just not.
Well, actually, I think the concern is this, that, and it applies sort of across the board, sort of whenever government does something, there's this sort of visceral reaction, sometimes negatively, to it. And since the government is now sort of moving all of these folks into this electricity procurement, I guess we're going to be more comfortable if people have gotten a lot of notice to say, look, the government's going to do this. And, and if you don't want them to do it, here's how you stop them from doing it. As opposed to just sort of assuming that, well, SOS works that way just because that's what happened out of the 99 Act. This is sort of doing something new, and I don't want a situation where people sort of find out about it by accident later on and say, what? And then, have a bad reaction to it. So I think all this effort of trying to tell them ahead of time, look, here's what's going to happen, and if you're fine with it, do nothing, and you'll go along. If you don't want it to happen, then here's what you do.
Yeah. Let me also, pardon me for interrupting.
No,
Mr. Chair.
you go ahead.
I was, Mr. Lapp, I mean, I was there and when we implemented this, and the reason, the way it was explained to me, I wasn't on the committee that did this, was that the reason they're going to be defaulted into SOS is that's where they are right now anyway. So it's not like we're we're not changing something that they were used to. That's the reason, and I think that's fundamentally different from what's happening here, because we are the legislature chose to default the ratepayers into something that they're not exactly used to. So there's a distinction between those two default scenarios.
Absolutely, and I'm in full agreement with comprehensive, broad education. I'm more making the contrast because maybe at some point, it's obviously not part of this proceeding, but there should be some sort of information that defaulting people into SOS for other customers is something to think about as well, and just to put it in the context. But we fully agree.
Well, and you may get an opportunity at some point down the road to make that suggestion to us. So is there another issue that came out of?
Commissioner Suchman had a question about creditworthiness.
Yep. Mm-hmm.
So in the draft chapter, section 8, provision 8, 8B lists 4 criteria that we will consider as we evaluate who the county's aggregation supplier will be. One of them is the price that they will charge for the service, also their performance capabilities, their creditworthiness, and operational capabilities. So creditworthiness is, we used that term specifically and intentionally to cover the broad, penumbra of factors that one considers in evaluating a counterparty's creditworthiness. We understand, we heard your feedback about wanting a little bit more detail, though, on that. And so the language that we would propose to append to item 3 would be measures that provide financial assurance associated with the supplier's commitments. That's right. Yep, that's part of 3.
So, can we take that out and have that, this is under 8, a description of the purchasing plan designed to save ratepayer money, including, and I would like that to be part of the plan. So
Yes.
can we have it under B, but have it be its own separate sentence after operational capabilities? So you just so you sort of do to enter and then have that be part of B, and well, I'd like it to, see, when you have supplier evaluation criteria, it's things you consider. I'd like this to be a requirement. Do you understand what I'm saying?
We will evaluate their creditworthiness.
No. I understand you're going to evaluate their creditworthiness, but I think that the measure has to be a requirement, because I actually want it to feed into a different section of the regs. So I think you actually have to have, so you have the supplier criteria, but you also have to have a requirement that for measures that provide financial assurance associated with the supplier's commitments.
I mean,
All of the other things are things you consider, but whatever mechanism you choose, it has to be part of your plan.
all of the, maybe I'm just not understanding, each of those sub-items are part of the plan. They
Well,
all work their way up.
Well, I understand that, but you could go through all of these 4
Yes.
and make a determination that, they're AAA rated, they're perfect, we don't require anything, we don't need a bond. And then all of a sudden they go south, and then you don't have anything in place. I think I would like to have there be something here that the utilities do this all the time. The utilities never do power purchases without a bond.
So are you comfortable with the language that we proposed as a sub-item, as Joey has in item 5?
I am comfortable with that language, but I'd like that language to be a requirement, not a consideration.
So the distinction here is under where I have it listed in 2 places. Listed under subparagraph B makes it part of the evaluation criteria. The same language listed as its own section C now becomes part of the purchasing plan.
I don't think you need it under the criteria. It's just what you do. So you're considering the criteria, and all of those conditions are there, but you're going to have some measure in place that protects the ratepayers.
So this is in the plan.
Yes.
So we're not going to have suppliers lined up when we submit the plan to you.
No, but you're going to identify a measure that you're going to have. You're going to be seeking suppliers.
Yes.
And one of the conditions for whatever supplier you choose, there's going to be something, whether it's a letter of credit, it's a parent guarantee, it's a bond, whatever it is, you're going to have that if you need to go to it. because something happens later on.
Right, but we can't commit in the regulations to what that specific
I don't think you need to, because all you're saying is you're just going to have a measure.
measures.
You're going to have some kind of measure, and then you're going to tell us in the plan
Yes.
whether you want to be very specific in the measure. I mean, because the problem is we're not going to be reviewing your rates, and so we're not going to have that comfort that I mean, we're going to have enough comfort, I suppose, that there is some mechanism there. And you'll have to explain to us why we should be comforted by what you're proposing. But at a minimum, there has to be something in there to protect the ratepayers.
Understood. I believe so. Okay, so which one are we going with? C.
So I don't.
instead of-
I'd like to take it out of. I don't think it's part of the supplier's criteria. I think it's a separate measure. It's just you're going to have that measure in place.
So as it's on the screen now, it is
Right.
listed as a
Right.
separate.
But I would love to hear from others about whether this
Okay.
makes sense.
This we can live with this.
We'd support this. Yeah.
Okay, so Mr. Wallace.
Yeah, Eric Wallace with the Retail Supplier Coalition. I think to Commissioner Suchman's questions, I mean, I was trying to understand exactly what you had in mind here, and understanding that licensed suppliers already have a bond in place. I was curious, when you say that it's associated with the supplier's commitments under the CCA, what are you envisioning in terms of the size of that?
Okay, if I'm not envisioning anything other than a guardrail. And so if you have a bond in place and in the aggregation plan that is part of what they envision as well, then maybe we have no problem. But I would like there to be reflected in this a path that we can go to if one of your members goes belly up for whatever reason, and everybody from Montgomery County has to migrate back on to SOS, and the utility doesn't have the commitments in place at that moment, and prices go up. I'd love Montgomery County to not be stuck at having to cover the differential or passing it on to the ratepayers. I'd much rather there be some mechanism, some hedge that's available to them to be able to go in and say, okay, for this 3-month period until we either get a new supplier or they're able to go back onto SOS, we have something there to protect those parties. If that language doesn't do it, then maybe you can offer something else. But do you understand what my concern is?
I mean, this is something that the concerns that you've described are issues that we're well aware of.
Okay.
These are things that we are going to be looking into as we evaluate our counterparties anyway. So this describes something that we were planning on doing anyway.
Okay. And are you comfortable with, now that you understand what my concern is with, because it doesn't specify what that measure is, it just signals to the county that we'd like to know what they have in mind when they're putting together the aggregation plan.
Yeah, I guess one follow-up question I would have then is, are you envisioning that this is a bond that the county would get put in place, or that the
Again,
supplier would put in place for the county?
I'm not envisioning anything in particular.
Okay.
I'm simply suggesting that we're going to want to know what that is. Your members are going to want to know. Certainly the county is going to want to know, and the ratepayers are going to want to know. And so if we've identified it, if we've flagged it here as something of concern to us, then you guys have, a couple of months, however long it's going to take for you to come up with the aggregation plan and come up with something that you think is going to take care of our concerns.
Yep.
So, thank you.
Do the commissioners have any additional comments or questions on these proposed additions to, continuing on the dialogue before lunch?
No, I think we're good, so.
Okay.
Thank you.
Moving on to, we're not quite past this chapter yet. We do have two two sub-issues. One of them relates to where we originally started in Regulation 3. And Regulation 3, E specifically, concerns the approval of changes to a commission-approved aggregation plan. So let me just get
We
to
put new
this.
language on it, by the way, that we submitted in our comments.
Okay. So before the commission are basically two versions of language for this section. Language proposed by the county and then language proposed by staff.
Yeah,
Unless-
we,
unless-
no, I
unless
think we edited it.
Joey put- yeah.
Yeah, this is 3E.
3E.
Yeah, 3E.
There,
Big E, yeah.
This is chapter 3 that we're looking at right now?
No,
Chapter
this is
11.
chapter 11.
Oh, chapter.
Chapter 11.
It's chapter
Still
11.
on
Chapter
chapter
11.
11.
Yeah, not
So,
three,
in-
but chapter. Yeah.
If the commission has the county's comments that we submitted in the table form, it's
What?
item 7 in our table.
Well, actually, before we get to that, I mean, should we start with staff as the why? Because they're the ones that want to make this change, right?
That,
Well,
so the language as filed is, what you see here is an addition of the word material.
Right.
But then, towards the end of June, there was new language captured in the side comment here from the county that proposes a CCA may not implement material changes to the approved aggregation plan other than changes to CCA basic and CCA optional services without commission approval.
Okay.
So long as the commission, if the commission were to adopt this language, then the county would agree to staff's addition, which is the highlighted yellow number 2.
So,
Now, since then,
yeah.
the parties submitted their written comments, and Montgomery County tweaked their June 27 language. So if you want to give me that new language, I can add it to the comment bubble.
okay, I think, okay, so.
Well, hold on. Well, actually, I have that, so why don't we go ahead and, I think it would be better if we
Do they want to speak
went,
about their views on?
that's right.
Okay.
That's right. So we'll start with staff on its view and position, and then go to the county, and then while they're doing that, I'll try to put new language in the new version in the
There's
comment.
new language from the county.
It's from our table that we submitted on July 7th. Item 7 in our table.
All right, I think I can explain staff's position without too much trouble. Originally, it didn't have the yellow highlighted. It just said the CCA may not implement changes without commission to the aggregation plan without approval. It was pretty straightforward. It was the idea being that if anything changed in the document once the commission approved it, the CCA brings it back in. It was raised that, well, what if we have a simple change or it's not a material change, and it's going to be hard if we have to bring everything in to the commission. So I think the compromise there was, all right, so we'll add material changes there, and we didn't want to create a scenario where folks were arguing about what that was, or there was perhaps an assumption on the county that they were making a non-material change, and so they could just change it without having that opportunity that other parties or the commission would take a look at it. So the yellow language sort of treats a change, so the county can make a non-material change, but they're going to notify the commission if they make that change 30 days before it goes into effect, such that if anyone at the commission or any other party that is on the receives notice says, hey, well, that's actually material, I would like that to be considered by the commission for
Mr.
for
Chairman,
approval.
I'd like to, what is an example of a non-material change? I know what materiality is. on a balance sheet, but I don't know what a non-material change would be in this context.
Exactly the point of why it was difficult to sort of agree to having material in there without this sort of, sort of pressure relief valve. But conceivably, if you needed to do a housekeeping change that didn't affect terms of the rates or anything of that nature.
Well, maybe Montgomery County has an example, idea of what they have in mind.
It's an excellent question, and it's what caused us to revise our proposed language, because given the complexity of what we're undertaking here and the different perspectives of the various parties and interests and commissioners, it's very hard to know.
Mm-hmm.
And so our position is that what we would do is, to the extent we, let's see. We would not make material changes to the plan other than changes to the basic and optional services.
Uh-huh.
So like the basic and optional services, if there need to be some modifications to the fuel mix or, the price, obviously, the types of offerings that are provided to customers, like, we can do that at will. We can change, we can have a time use rate, EV rate, solar rate, wind, whatever. But to the extent we make material changes like changing the complexion of the oversight board, for example, changing the number of members, like that would be material, certainly. Significant changes in notice periods, would be, or changing significantly the number. If we had said in the plan, let's just say we said we're going to provide X number of notices and we changed that, that would be, things like that would be material.
I mean, I can see both sides of this argument. On the one hand, this is a pilot program, and as a result of that, the commission wants to have perhaps stricter oversight than we would have of BGE or Pepco or something. On the other hand, I can see where there is an advantage as you're managing this process not to have to come back to us for every insignificant thing. And, so I'm trying to, this is all very new to me, so I'm trying to figure out
So
which,
So what the idea is that look, we're going to be cautious by nature anyway, right? And so to the extent something is material, we won't do it without approval, and then non-material changes we'll include in our annual report. So we'll keep a running tab of everything we change, everything we do differently than we originally anticipated. In addition to the annual report, there are a number of measures. So there will be monthly enrollment reports. So to the extent there's a dramatic change in the number of customers, you'll know that every 4 weeks. You'll get an enrollment report that will show whether there's a significant move up or down. Again, we'll have the annual report. The work group also will be providing an annual report. And there's a catch-all provision in the regulations that require us to provide periodic event monitoring, according to which we are required to notify the commission of any circumstance, event, condition, optional service termination or modification or obligation likely to cause a material migration of customers from the CCA. So that's a catch-all. So we, in addition to the demarcated reports that we have to submit, we also have to be on the constant lookout for anything that we believe the commission might be interested in knowing about, and then notify you as well as other stakeholders, as quickly as is reasonable.
Let me ask a process question. Maybe this is best directed to staff. Let's say we went with this language, material, and with the other language, the 30-day language, and we decided we wanted to walk that back and change that. Can we just do that on the fly, like 3-4 months from now? Could we? How set in concrete is this?
Well, once you put these in regulations, they're in regulations. We'd have to go through another rulemaking process to make that change.
Gotcha. Okay.
Well, except I believe that we can we can probably revisit this if we see that there's a trend in another provision. So I actually like the idea of not getting overly burdened with complaints, particularly because you're going to be providing us with you're going to be sending us any non-material changes, and then you're also going to be giving us monthly reports on how you stack up with SOS, and you're also going to note if there's a big difference. And so so if we don't put your language in there, then I think we can find ourselves doing one hearing after another with people complaining that the rates were changed. So I'm.
What she said.
Yeah, I actually think this was fine.
So our first provision is consistent, including the word material, is consistent with, or mostly consistent with what's in the draft regulations there. So our number one here is basically the number one there with a slight modification, but I don't think it's material. No material. However, there is a significant difference in the number two. So the number two, which is on the screen below, if you wouldn't mind scrolling down slightly. So that's where it gets a little, bit more problematic because, can you close the pages maybe? Is that possible? Okay. So if we have to, those provisions are a little bit contradictory because the first says that we can't make material changes, but it seems like we can make
Yeah, I don't really, I kind of agree with you. I'm not sure what is added to number two, except that it's just going to give us more stuff to look at. I mean, if it's not material and we're already getting information from them every month anyway, I think if they want to change the color of the paper that they send to their ratepayers, I'm really fine with not knowing about it. I mean, unless you can convince me that we need to.
Your Honor, you're going to, if I may, you're going to approve the aggregation plan, and that's going to have, words in it that you're going to say, we've approved this. So that's probably not going to cover things like the color of bills or something of that nature, but it might have terms and conditions or other elements of the schedule that you have approved. So if that changes, they would be required to bring that here to ask you to reapprove it. Otherwise, they, if you took this to its extreme, they could make any change they wanted after you've approved it.
But then those would be material. I mean, I'm just, and I guess I'm just asking you, because we're trying to get to a place where it makes sense. I mean, if we make them tell us everything they're changing, we can get overwhelmed with paper, and then we lose the value of looking at what's material. So
It would be limited to the document that you approve, which is the aggregation plan. If they change elements of that, and they're making the decision for it to be non-material and making the change and simply providing the notice. If they said, hey, this is probably a material change, we're going to apply to the commission to get permission to make this change. It's things you have already approved once, and it would make sense to continue to approve those things as the pilot is.
well, okay. So
going
instead
forward.
of 30 days, how about if the county every 6 months just tells us what they've changed over that 6-month period that was not material, and then somebody in our office will just review it to make sure that it really is, because I think every 30 days is going to overwhelm our limited staff.
And just so I understand this, so what you're envisioning is that every 30 days, if they made some non-material change, they would send you a notice. You could look at it. If you decided it was material, you could raise an issue about it. But if you did nothing, did not respond, then they just go ahead and do it, right?
Yes. But presumably this wouldn't require monthly changes if the aggregation plan itself is changing that frequently. I think what we're trying to capture here is
is a change that, perhaps would result in a customer's rate changing or the customer's terms in particular, since you're not approving the rates. So if that would develop into something that would surprise a customer or otherwise, it's not intended in any way to burden it. But if
Well-
you've approved something the first time, we didn't want to create a loophole that allows changes to occur after the approval process.
But there's another problem though, is, if for some reason they don't send you this notice, that theoretically creates a violation, because they didn't send you the notice, even if you weren't going to do anything with the information you got because it was a non-material change. So I'm kind of leaning toward this idea that if they're filing these reports on a regular basis anyway, maybe this information can be included in that. And then if you look at that and you decide, oh, that was really a material change, then we can cross that bridge when we get to it, as opposed to this affirmative requirement on them to make this filing every time they change a period or do something like that that's really minor.
And then not wait 30 days before it can go into effect.
Right.
I really like that. I mean, if you're submitting the stuff every 30 days, it could be at the end, oh, by the way, we've changed the color of what we're sending to our ratepayers. And then you'll have the ability to look at that and say, oh, no, that's material, and then we can figure out what to do.
You're right. I mean, certainly, staff is just providing our
Sure,
recommendation
I
in this
understand, yeah.
regard. I think we are thinking more along the lines of a change that would impact a customer such that they would be unhappy with that. And given that some changes may be things that customers are defaulted into, they
But in that
potent-
case, I mean, won't the customer take action? I mean, if the customer's aggrieved, then and there's a whole separate complaint process as part of this thing for customers to voice their problems, right?
Certainly, a customer has a complaint with it, but it might be difficult to find anything wrong with that particular situation if the CCA hasn't done anything that was outside the commission's approval. So,
Well, I mean, we've heard from everybody except that. No, I'm talking you. Do you have an opinion on this?
So, can I give some comments, Mr. Chair?
Oh, sure. Yeah. Okay. Yeah. I forgot you were.
It's quite all right.
Sure. That's fine. Go ahead.
Excuse my voice. I'm getting over something my daughter gave me. So,
No, that's fine.
if you look at the information that is required to be given in the aggregation plan, so Mr. Chen, can you go up to page 4? So there at the bottom, 11. So as part of the aggregation plan, they have to tell you the initial and anticipated service offerings. So for example, if it is going to be a seasonal rate, so for example, they could have a seasonal default rate, different rates in the winter, different rates in the summer. If it's going to be a time of use rate, if it is a tiered rate, and if you scroll down a little more, there's some key, really big rate design things that they're going to tell you about the rates they are going to offer. So I read the proposed language from the county. A CCA may not implement material changes to the approved aggregation plan other than changes to CCA basic and CCA optional service. So I read that as, the county comes in, they say, we're going to give you a flat basic service rate, and we are going to update that rate every 6 months. Here's our true-up process. They are now saying they want language that allows them to change that after you have approved that to, they could potentially say, now we want the default rate to be a time of use rate. Now we want it to be a tiered rate. And then regarding the notification through the annual report, that is something they file each August. That's in chapter 19. So you would potentially be getting notice of changes and potentially major changes to the service offerings, and this is what customers are paying for. They're paying for CCA basic service, or they're paying for one of the optional services. Major changes, up to 11, 12 months after the fact, of it occurring. And then, there is monthly reporting on enrollments that is intended to show the number of customers enrolled in each of the service options by service territory. There is event monitoring, but major changes to the structure of what customers are actually being served by, we think those material changes should go to the commission, and if the CCA does not think they're a material change, they should get notice of that. Thank you.
Mr. Chairman. Okay, so that certainly makes sense. The question that I have is, if we've taken the rates off the table so that we're not being asked to approve rates, I'm assuming that also means time of use rates. And so making those changes, even if we were to get notice of that, can we really speak to that? I'm just sort of asking, because I don't want to be required. I don't want to require you to submit information to us that we won't rule on, because then there's what's the point? So this is a question maybe for staff, and I understand that you'd like to respond as well. But if we're not addressing the adequacy of rates, then changing those rates, what would be the point of us knowing about those?
This would only impact something that you've already approved once. So if you have no oversight over rates of any kind, you wouldn't have made those approvals when you approved the aggregation plan. This addresses anything that you actually have approved in the process of approving the aggregation plan. So if a change is made to it,
But the example we were given is the changes of rates.
you may have been, if you have an aggregation plan that has like Mr. Hoppick's example, is it has a flat rate for basic service, and you've approved not the rate itself, but that's how it's the terms of it. That's how it's being provided. If what is then changed is that the default goes from a flat rate to a time of use rate, then we are thinking that it's best for you to re-examine that and approve that as well.
Okay, so if we go back to this language, a CCA may not implement material changes. So so terms of service would not be the rates, correct? Or, I mean,
the rate itself would have to be a price per kilowatt hour.
Well, I'm just trying to get to what your concern is, and then still be consistent with what it is that we are actually approving. And so taking rates, I mean, we're not going to be looking at rates, so having them in or out is not really relevant. Material changes to what's in the aggregation plan. I mean, can it be, well, CCA basic and CCA optional services includes rates, but also terms of service. So,
so you're not
help me out. I mean, do you understand what I'm asking? I'm asking you to find a path forward that reflects what it is we can rule on. So it doesn't make any sense for us for this to include rates if we're not going to be addressing rates.
I don't think Mr. Hoppick was suggesting that you would be approving rates.
Well,
I think
time of use rates is rates.
I think he was talking about the structure, the difference between having a rate that was applicable 24 hours a day versus a rate that had different rates for different times of the day. So the reason I understand that you're not approving the rates themselves is because you're not approving the actual procurement cycle that the county is going to use to obtain the service. But you very possibly are going to look at whether or not the rate provided as default is a time of use rate or is simply a flat rate similar to the way standard offer service is provided. So if what you'll likely to be able to have from the county at the time the aggregation plan's in front of you would be is like we're going to have a flat rate It's going to be, a rate that's 24 hours a day. As Mr. Hoppick mentioned, could be a seasonal rate that's going to change periodically, but you'll have been told the sort of the nature of the rate, how it's charged to customers based on the usage over a particular period of time.
Okay, so I'm new to the commission, but it was my sense that we were not addressing those aspects, that seasonal rates, time of use rates, that's all part of the rate that you're going to be charging, that they're going to be charging ratepayers. I didn't have the sense that that was something that we were going to be looking at. So getting us that information, it's not going to be of any use to us if we're not in a position to rule on it.
If it was not brought in front of you during the aggregation plan approval process, then you wouldn't be, approved. There'd be no change to approve because you wouldn't have made that particular decision.
You have, if you can.
Well, let me pursue a different angle, though. I thought part of the concept behind this legislation was to actually give the county that sort of flexibility, that they could create these different rate plans, so to speak, and as opposed to, having it come here and then go through the whole approval process and things like that, that they would have this. And the customer's choice is, if they didn't like it, they could just opt out. They always have that ability to leave, so they're not like stuck permanently. So I guess I'm not quite understanding along the lines that she's talking about. I mean, if there's nothing that we can do about it, then what's the point?
So the previous decision the commission made addressed the procurement. They were not approving contracts. They were not approving the actual price being paid. So presumably, if the offer is similar to standard offer service, which is much of what we've heard, thus far about how the default service would be provided, you'd be notified that there's a rate structure and here's what it looks like. And once we procure the energy, the rate that customers pay, the retail rate, will be based on that procurement. So you can approve that as a rate structure with those terms that indicate that this is a flat rate. It's it's 24/7. It changes in the spring and the fall. If that's what you are happy with, and that's what the county wants to provide, then you approve it, and that gets written in. You approve the aggregation plan document. If subsequent to that, the county says, well, you know what, let's actually put everyone on a time use rate. I think we're going to like that. And those rates often have, could be based on a similar procurement, but they're going to have potentially, rates that are much higher during the peak hours and much lower on weekends or off peak. Some customers would love that. Others might be surprised if that happens to them. So that would be the type of material change that I think everyone would expect would be brought in front of you for reapproval.
Any other?
Could I?
Let me. Oh, well, yeah. So actually, I was going to turn to the county. So whoever from the county wants to respond, go ahead. So
I just want to address one thing, particularly Mr. Van der Hayden said there, that the county might change to a time of use rate, and the customer might be surprised by that. I'm concerned about the perception that customers are going to be surprised by anything, notwithstanding that people may not look at everything they receive or go to the county website or look at social media, whatever outreach we're going to do about this. In the same way that utilities provide in your electric bill, they say your rate is this, effective May 1 or June 1, your rate will change to this rate. Your rate will change again in October. We will tell you that rate once we've procured the electricity. There's a notification ahead of time of when the rate's going to change, the terms are going to change. The CCA will be doing the same thing. So there won't be any surprises for anybody, and I'll say who's paying attention, which you will be, we will notify you, we will make every effort to notify customers. We're going to do the same thing the utilities do in that we're going to procure all the electricity ahead of when a customer is going to pay for it. So they will have advance notice of any changes in the terms and the conditions. And
okay.
Mr. Chair, I think in order to try to move this discussion forward, I think the commission ultimately just will need to decide, how deep it wants to get involved with the CCA. There is a very robust and comprehensive approval phase of this, where the commission will be receiving very detailed information as part of the aggregation plan. And when the commission approves the aggregation plan, I think the question for the commission to decide is what next?
But sitting here right now, what we have to decide is this sort of 30-day notice provision, correct?
Well, there are two pieces to that. So in terms of material changes and non-material changes.
Right.
So the non-material changes is really just information gathering. And whether or not you want it 30 days, you want it 6 months, that's probably a small detail.
Okay.
More so, I think what the contention here, and really the broader consideration for the commission, what I was referring to, how deep you want to get with the plan is whether or not you want to go in the area of material changes. Does the commission want to exercise that level of oversight, looking at it?
And it's not just, it's that it's the county cannot implement. They can't do anything.
Right.
Until they get commission approval. It really does stymie the program. If they want to change from seasonal to time of use rates, they can't. They're stuck. It seems to be sort of counter to what we're hoping this program would be able to do.
Right.
So if we adopt the county's suggested language, though, that says the part that says
the new
shall not
green
implement
on the
material changes to the approved aggregation plan other than changes to the CCA basic and CCA optional services without commission approval. If we adopt that, then they're able to make these changes that we've been sort of talking about hypothetically.
It gives the county the most
Right.
flexibility.
Right, yeah. So I guess the question for us is, are we comfortable with giving them that authority?
Yes.
Okay, Commissioner O'Donnell, you have a view on? Okay, all right, so that's what we're going
I'm
to.
sorry, Mr. Chairman, I was trying to get unmuted.
Oh, I'm sorry.
Good, I'm good.
Okay, all right, so
Your
I
Honor.
guess, and so am I. Oh, well, actually, one, all right.
Yeah, if I could just weigh in,
Sure.
we fully support that. I thought that it was a little ambiguous. I had a slight suggestion to that language, and maybe I can share it here. I
Sure.
think that that it would be better not to have the comma other than changes to CCA basic and CCA optional services, and move that to just a separate sentence that just says all changes to CCA basic and CCA optional services shall be considered non-material changes, or something along those lines. I think it's,
Does that work?
The county has no objection. We appreciate the clarification. Thank you.
and I guess I would just add that I think this is very consistent going back to the statute, where the statute says proposed terms of service, et cetera, unrelated to the actual cost of the electricity supply, and time of use versus, a one-time rate is related to the actual cost of the electricity supply. So I think this is consistent
Okay.
with the statute.
So with that amendment, we'll make this change to the regulation. So.
You want to say first?
This, you don't need more. It's like two different alternatives.
In terms of the notifying the commission about non-material changes, are we at 6 months?
Yes.
Okay.
Joey, you would be taking out the prior to the effective date, so it would just be just a notice every 6 months.
Yeah.
Okay. One last sub item, assuming we can move on, is we'll call it it's an issue that was raised and edits that were raised by the Retail Supplier Coalition in their comments, so they were not reflected in the work group filing, related to contract summaries and a contract summary requirement. I'm going to, at this point, invite Eric Wallace to tell the commission a little bit more about it.
Yeah, thank you, Chairman, Commissioners. This is an issue that we had raised in our comments. We've raised it in previous rounds of comments, and it gets to the core of how this CCA offering is going to be, sort of entering the competitive marketplace. And we heard from OPC earlier that the CCA will be a competitive benchmark against retail supply and SOS in this marketplace. And there's also been some discussion about the inherent advantages of a government entity and entering a competitive marketplace. And at the end of the day, when you look at the statute, the structure that we have in the statute, it very clearly contemplates a three-legged stool that includes retail choice, SOS, and the CCA. And so the Retail Suppliers Coalition's concerns in general in the comments throughout this proceeding, and specifically with respect to this contract summary disclosure, is that the rules should be structured to empower customers to make an informed decision about which of those three shopping options they want to pursue. And the contract summary is a tool that the Commission developed back in 2016 in the wake of the polar vortex that lays out the standard kind of most material terms that the Commission determined that a customer would need to know to make an informed decision, such that even if a customer didn't read through the terms of service, that if they had that contract summary, that would provide the most, kind of pertinent information. And so in these rules, there are many different things that are to be provided in the aggregation plan with respect to the terms of service. There's an FAQ. There is I'm trying to remember the other item. There's a consumer pamphlet that needs to be provided, the terms of service. What's not reflected there is this contract summary concept. And so the recommendation for this section, and it appears in other related sections as well, is that customers be empowered to make an informed decision between options by having this contract summary that they can compare. They can go to the Commission's website, they can look at their shopping options, and when they click on a supplier offer and they go to pursue that, they'll be presented with a contract summary that then they can compare against the offering that they're looking at from the CCA. And so we just think it's important that this concept be addressed in these rules so that customers do have the ability to compare those same product components side by side when making that decision. And there's a related issue that we heard this morning, and I saw it also in the comments that the county submitted, which is their suggestion that there is no contract between the CCA and the customers. And I think that gave us some pause that they would suggest that there's no contractual relationship there. There are terms of service that are contemplated in the statute, and so I think as a court is looking at this written document that contains obligations and responsibilities of both the CCA and the customer, the suggestion that it's not a contract, I think is something that stood out to the Retail Supplier Coalition. And as we look around at other jurisdictions that have CCAs, customers are generally getting the same type of information about the CCA offering that they're getting about, under the existing retail choice rules. And so we think that it is a contract and that those terms should be enforceable against both the CCA and the customer. And the idea that it's not a contract was cause for concern, and whether, what would that mean in the event, would customers be limited from their ability to pursue contractual remedies if, the CCA does not deliver, what they're obligated to in the terms of service they provided. So I think that's just an important issue that, is related to this contract summary concept. But more broadly, I think that the commission is sort of called on here to decide how this will be structured and whether or not this is indeed going to be viewed as a contract. And that then flows into a lot of the consumer protection issues and related disclosures in the commission's rules with regard to existing suppliers, right? And this aggregation supplier that's going to sit in the middle of this arrangement, but also, consumer protections that apply under the, under the commercial law article in state and federal laws with respect to contracting. Those are all rules that apply to retail suppliers. And as we have a CCA entering this marketplace, they are certainly playing by a different set of rules with respect to the basic service, right? This opt-out service. But then, there are also a suite of optional services. And, I think we would submit that with respect to the basic service, the only thing that's really changing here is consent, right? That you can be opted in, automatically, and you exercise your choice by choosing not to opt out. But with all of the other products where you are affirmatively selecting something, I think you're very clearly entering into a contract with the CCA to provide the services that both parties have agreed to and have memorialized in that contract. So to summarize, kind of two issues here, the general kind of contract framework, and then also, this disclosure document, whatever you want to call it. It's a contract summary in the existing supplier rules, but we think that's an important tool.
Any questions?
Yeah.
Commissioner Barve.
So I and my wife decide to participate in the CCA, and the CCA enters into an arrangement with Fast Eddie's Renewable Energy Company. So is my contract with Fast Eddie and CCA is not in any way? I'll let you explain.
So, Commissioner Barve, you don't have a contract, just like you don't have a contract with SOS. There's implied, you don't have a contract with SOS. You have an obligation to pay your bill, your electric bill, your water bill, all these utility bills, there are obligations to pay, but they're not contracts in the sense that one thinks of when engaging with a private entity. Like Mr. Edwards showed on the slides this morning with the diagrams, there are three general models, and you may have noted in the drawings that there was a little picture of a contract actually in each of them, and that was there for a reason. And it showed that in the SOS model, there's the customer, and then there's the utility, and the contract is above the utility. The contract is between the utility and the suppliers. In the retail choice model, there's the customer and there's the retailer, and the contract is between the customer and the retailer. In the CCA model, it's the CCA and customers at the bottom because they're basically the same in a sense. And then there's the aggregation supplier. So the CCA, the county, signs a contract with the aggregation supplier to go out to market, purchase energy, and deliver it to the utility, which then delivers it to the customer.
So to make it clear, I don't have a contractual relationship right now with Pepco. I just pay the bill.
Well, I'll let Pepco characterize the nature of the relationship between them and their customers, because there may be some sensitivities in the exact wording there. But broadly speaking, in the sense that you do not have a contract with Pepco, in the sense that you have that customers have contracts with retail suppliers.
Got it. Okay.
And so,
I guess we have
right. So when a customer is enrolled with the CCA, they'll be enrolled in the basic service. And then to the extent a customer wants to enroll, or wants to receive, they're enrolled in the CCA, to the extent they want to receive an optional service, more renewable, less renewable, time of use, EV, whatever, they just check a box. They log into their account, check a box, everything stays the same, except they get more renewable or less renewable, time of use, weekends, nights, whatever. We'll show the price. They just check the box. I agree. Done. That's how CCAs operate.
Do you want to address? Do you want to address the contract summary issue? Because I take it you don't want to provide those, or don't feel you need to provide those.
Please.
So the language that I believe, well, the language that's actually in the attachment that the Retail Supplier Coalition submitted, it's actually referencing Comar 20, Chapter 11, but I believe it's Section 3. That language comes from what we're required to give to customers in from the statute. So the statute lays this out extremely clearly.
Yeah.
And we there's actually discussion about how, the usefulness of putting the statutory language in the regulations, and we did it very specifically. We're required to, at the formation stage, it's supposed to include some things, and then at the opt-out stage, it's supposed to include things. So I really feel like there's a reason for the language, and I don't think there's any. Yeah, the contract summary would not be appropriate to be added at that point.
And then if the key, generally speaking, if I'll just, I don't have the precise list, but the general key terms and conditions, if you will, are things like duration. What's the contract duration? What's the price? What's the notice when the price changes? Early termination penalties, things like that. So with the CCA, whether under basic or optional, there is no minimum commitment. Customers can come and go at will. There are no early termination penalties. The rates are provided clearly, and the regulations in other locations where we haven't gotten to yet today talk about the notice that we have to provide to customers before a rate changes. So all those key factors are either aren't relevant or they're provided for elsewhere.
Does either staff or OPC have an opinion about the contract summary issue?
We would agree with Montgomery County.
I think the concern is that there's useful information in the contract summary. I think staff has taken positions in other sections of the regs where we view an optional service as very similar to a customer making a choice to select a particular type of product. So I think the reason those protections are and those requirements are in the existing retail choice rules are so that customers understand what they're buying and what the terms are. So that if there's a way to provide that in some other way without calling it a contract summary, if in fact there is no contract, I don't think we've created that in these rules, but it is a useful protection for customers, and so it would probably be good to have that in some way continue.
So I guess first I would have a big problem with kind of bootstrapping identification of anything involving what the county is doing as contract by sticking contract in the regulation. So but I'm trying to understand what information you're referring to that should be in this.
Sure.
Okay.
I think I have it. I have Comar up here, if I can get to it. So I think the reg, if I'm correct, this is 2053 07. Sorry, 0708. So Regulation 08 in Chapter 7, and 2053 is the subtitle for retail choice. So if you go down to B, contract summary, it just lists a number of things. Copy of the contract is one of them. I'm just sort of paraphrasing. There's a requirement regarding telephone solicitation, but I think the county has indicated they're not going to do that, and we have a regulation that says that. And then it says if the contract is completed through the internet, the contract summary shall be available online, transmitted to the customer by mail or email. So I think those are the elements that sort of would apply to the information being provided. But the contract summary is going to give you terms and conditions and things of that nature. I think that's actually something that the suppliers addressed in their comments as well.
Mr. Trout.
Thank you, Mr. Chair. This is not my issue, but I'm going to try to help. There is not a contract per se between utilities and customers. There are tariffs, there are regulations, there are statutes, and that is because we have a statutory and regulatory duty to serve. That is the critical distinction between a utility and a retail supplier. The retail supplier serves only the customers that it chooses to serve. A utility has a universal obligation to serve. In that respect, the statute, I believe, has created in Montgomery County, with respect to the CCA, a duty to serve. And so in that respect, the county is more analogous to a utility than it is to a retail supplier with respect to this issue. Now, does that get you all the way home in terms of resolving this question? I don't know if it does or not because, as I said, while we don't have a contract, we have tariff language approved by the Commission. We have the regulations approved by the Commission. We have the statute that the General Assembly has given both the utilities and yourselves to guide. But you have many of those same elements here, or are framing many of those same elements here for the CCA. So I hope that helps a little bit.
So, Mr. Chairman, if I may respond.
Actually, let me just check. Any other questions from?
Well, if I could just, and maybe you can respond to me as well. Actually, I found Mr. Trout's statements rather clarifying, because for me, it also feels like the county is kind of stepping in the role of a utility once it's sort of making commitments to ratepayers, and so to the extent that you sort of superimpose, I mean, you can call it something other than contract, and if there are terms that are not relevant to what the county is doing, then it would serve to confuse the ratepayers. If they're looking at things that you do, it's not really reflected in what the county's submitting because they don't need to put it in, and then it'll suggest to ratepayers, well, you're going to be better protected by a retail supplier than you are by the county, and that's we don't want to confuse people. And I'm not saying that you're going to be, I'm not saying who's better and who's not, but if we've been concerned about information and making sure that customers have the right information, the last thing we want to do is impose on this process information that can serve to confuse rather than educate consumers.
And actually, just before you start, let me check. Commissioner O'Donnell, do you have any questions on this?
No, Mr. Chairman, I don't.
Okay. So go ahead, Mr. Wallace.
So a couple of points. First, in every jurisdiction that I've looked, courts have interpreted tariffs using principles of contract interpretation, right? And tariffs are contracts between customers and utilities that are established not by negotiation of the parties, but by a regulator, reviewing and approving those terms. So I think this notion that there's no contract between customers and the utility with regard to SOS, I think is wrong, and that there is a contract there, and that is a tariff, and that's how, as I've looked at it across a number of jurisdictions, that is a contract, and that is viewed as a contract by the courts, and so I think this notion that there's no
I don't think so. But so I think you're not. I mean, the utility doesn't provide me service because a tree took down the wires. I can't sue them for breach of contract. I think that it's not, from my perspective, it's not helping your case if you argue that these are contracts, because I don't think they are. But anyway,
Mr. Chairman, I have a question. So currently, I'm getting my power from Pepco, and let's say, for the sake of argument, that I opt the CCA. Because the CCA does not have the kind of contractual arrangement as you would like, what do I, as a consumer, lose? What have I lost? If we don't adopt the language that you want, and I pick the CCA, what have I lost as an electric rate consumer?
Well, I think with respect to this language about contract summary, it's the concept more than the phrase that's important, right? So the contract summary is a document that the commission developed that, whether you, in the context of the CCA, whether you call it a, CCA basic service summary, a CCA optional service summary, a contract summary, it's the content rather than the name that's important. The reason we included the name here is because this is familiar to the commission, because this is something that's been developed,
well, why don't you tell us
many years ago.
what's in a typical contract summary?
Would it help if I pulled the definition up? Because I think the Supplier Coalition did provide a definition.
Well, I think the definition references the rule. The contract summary and the contents itself were developed by staff and approved by the commission back in 2016, and it's a form that was put on the commission's website.
Yeah, okay, so tell me what,
Yeah.
I have a sort of a sense of what the county is going to be providing, but why don't you tell me what's in the contract summary for your members or your clients?
Yeah.
So that we can understand what you think, because I'm assuming that's what you think needs to be in here somewhere.
Yeah, it's a box that has the most material terms. So supplier information, price, term, duration, renewal provision, incentives, cancellation provision, contract start and end date. Those are the core things that are in there. At the bottom of the document, there's a cross-reference to the terms and condition of service where the customer can go.
Okay, so those core items,
Right.
are those going to be in your aggregation plan?
Those are, so, many of there is no minimum duration. There are no early termination.
Because there's no contract.
Well, either
Or-
way.
or-
I mean,
but,
there
okay,
is
so-
no minimum,
Okay.
there's no contract start, the contract start date is the date the customer decides to enroll, and it ends when they decide to leave. There's no commitment. And we have similar to the utilities, under the statute, we have an obligation to serve any residential or small commercial customer who wishes to be enrolled in the CCA. We have an obligation. A legal obligation to
Right,
serve.
and you have no obligation to serve. I'm wondering if we're just trying to compare apples and oranges.
And I think those measures, those factors that Mr. Wallace just mentioned, very important for retail suppliers, but we literally just don't have those. And to the extent there's a fuel mix, that will be on the website when a customer says, I want more wind. It will say what percentage of wind versus other sources it will be.
All right, so let me cut to the chase here. The statute made a specific provision to say that the CCA is not to be considered a retail supplier. I interpret that to mean that we're not to apply the rules and regulations that apply to retail suppliers to the CCA. And I think that includes this particular provision. As Mr. Trout discussed, the CCA is more utility-like than retail supplier-like, in the sense that they have this obligation that they've voluntarily taken on to basically serve everybody, except for the people that decide they don't want to be part of this. Just like the utility basically serves everybody, who, I guess, unless they decide to go off the grid. So, unless there's some dispute from any of the members on the commission, we're going to deny the change to require the CCA to provide a contract summary.
Yes.
Okay, all right.
Okay, thank you, Mr. Chair and Commissioners. I believe that addresses Chapter 11, assuming there are no other questions, concerns, issues that the Commissioners yourselves want to raise, and we can move on to issue number 4 on the agenda. Issue number 4 concerns Chapter 13, so I will just go ahead and pull this up. Again, just for the benefit of those in the room, Chapter 13, or this version that I've put on the screen, by and large, is the version that has been filed with the Commission. However, where parties, Chapter 13, yeah, where parties in their written comments offered additional edits and recommendations, I did try to fold those in, and you will see those in the comment bubbles or in redline. So this chapter addresses the CCA statutory requirement that the CCA aggregation plan must include an analysis of historical and forecasted trends in electricity prices and a purchasing plan designed to save ratepayers money. And so the issue is really about purchasing plan descriptive analysis, or what level of analysis needs to be applied to the purchasing plan. The language that you see is staff's proposal, which requires that the county include in its aggregation plan an analysis and explanation of how prospective CCA customers will save money under the CCA. It describes how the CCA would meet the legislative requirements under Public Utilities Article 7.510.3 D2. So, if we look at Regulation 2, you will see that the county opposes this Regulation 2 in its entirety because it goes beyond the statute. That between Regulation 1 above it and the county's own proposed aggregation plan, the information that would be captured into is already or adequately covered. So with this, we'll see if the county or any of the other parties wish to make additional comment.
I thought that Mr. Chin described our position very accurately. But we're available to answer any questions, of course.
It feels like I feel like I've got like regulations all over. And I feel like I've seen somewhere else in the regulations that you're required to do a comparison of how well you're doing against the SOS. Is that
That
right?
is a separate, that's a separate issue, yes.
The price to compare issue is a separate, well, what I mean by price to compare, there is the price to compare, but then there's also the comparison of any price volatility of the CCA and using the SOS as a benchmark
Right,
to that. That's a separate issue. What we're talking about here is the historical and forecast electricity price trends. So under the statute,
Oh, okay. Okay, so what this would ask you to do is sort of analysis of how well you've done, or how well you've done, because this is new.
if you want to think of it this way, commissioners, as part of the aggregation plan, the county has to, of course, submit for approval a purchasing plan. And the purchasing plan is designed, or supposed to be designed, to save ratepayers money. And part of that, in the statutory requirement, should embody or reflect an analysis of historical and forecasted trends in electricity prices. So this, again, will be...
Okay, but that is not, and then you're going to have a separate, assuming this were to stay in place, so then you'd have a separate requirement to actually inform us of how you've actually done.
That's exactly right, Commissioner Sushman, right. So the idea here is that, let's just peel the onion back one layer further. the county will be procuring energy on a schedule that is consistent with the schedule in which utilities purchase power today under SOS. There will be some slight differences, but the schedule will be basically the same. Every 6 months, 25% of the load. The idea is that the prices will be like highly equivalent, highly comparable. By complying with this provision, we will take our approach, which I just described in a nutshell, and we will overlay that onto a chart of how SOS prices are projected to unfold. And because our procurement schedule is basically the same, the lines will be basically on top of each other the whole way. Now, the purpose of that is to give the Commission the assurance that in executing the CCA, we're implementing a plan designed to save ratepayers money. Contrast that with another approach that could be taken, which we will not take, which would be where we would purchase power on a different cadence, different durations, different timing. We would take that, and then we would make those projections, and we would show you what that curve looks like as compared to what the projected SOS curve is. And maybe it would be higher, maybe it would be lower, it would be whatever it is, and then the commission would make a determination as to whether that seems like a good idea or whether it seems realistic. What the commission can anticipate receiving in our plan is what I described first, which is that our purchasing approach will be consistent with SOS, the curves will line up, and so providing the types of graphs that are listed in O1 in the trend analysis will provide you with the information the commission needs to be comfortable that the purchasing plan we're adopting is designed to save ratepayers money. The requirements in O2 we consider to be beyond the scope of what's required by the statute and not particularly informative to customers. And so for that reason, we believe that it's additional information that's unnecessary and just not helpful to customers.
Mr. Chairman?
Sure, Commissioner Barve.
I believe I agree with the county on this, but I'm curious about one thing, and maybe staff can help me. This language that says a determination of the likelihood that customers would save money as a result of the application of CCA rates compared to prevailing energy options. Is there someplace else in our regulatory framework where we ask a utility to make an assessment of likelihood of saving money? Is that, I mean, have we done that before elsewhere?
None of the procurement for SOS requires that sort of, it accepts the results as provided after the procurement's occurred.
I thought that might be the case. Thank you. Thank you, Mr. Chairman.
Commissioner Schlesinger.
Okay, so you talked about what it is that you would be doing under one. If you could just talk to us about what additional efforts you'd have to go through to comply with number two.
Well, I think that Commissioner Barve identified, the most concerning of the three, which is this determination of the likelihood that customers would save money. It just strikes us as a little speculative, a little also subjective. 87.2%. So it's not really it's also not really actionable by a customer.
Well, I also wonder if it creates a vulnerability for you.
Yep.
If you put out this information and people are waiting for it, so competitors are waiting to see this, and then will use this to slam your program, even though the analysis is not really much more than taking tea leaves and Okay.
Right
I-
now,
I see what you're saying.
And then the first one is pretty redundant with O2A is pretty redundant with O1B, because in O1A we have to look at historical, and then in O1B we look at forecasted trends, and then O2A is also projected CCA rates.
Well, the other thing is, because again, it's a pilot.
Right.
We're mostly interested in how you've done.
Yes.
As opposed to how you're going to do.
Exactly.
And we're going to get that information. So you're going to be letting us know how you're doing in comparison to SOS for several years.
Yes.
Plus, I mean, in reading the statute, the language says a purchasing plan designed to save ratepayers money, which in my mind is actually different than sort of this actual guarantee that, you know, people are going to save money from it. I mean, it strikes me that it's closer to the description the county's offered about what they're intending to do in procuring electricity and the analysis they're doing. And, you know, their goal is to save people money. But, you know, it strikes me that the language that you're suggesting is almost requiring a guarantee or a proof that it actually will. And that's not what the statute requires them to do. So.
Mr. Chair, I think we were also responding to some direction we got in some of the previous rulemakings, and especially I think the initial rulemaking where there was a sort of a, at the time the commission chose not to approve the rate itself. There seemed to be an interest in having a way at the time the aggregation plan was approved, looking at how the procurement would be occurring such that the commission would have a feel for whether or not there was going to be a successful ability to, you know, provide the savings. So I think what this is asking for is a projection based on information that, you know, potentially would be, you know, confidential at the time, but, you know, we have means to deal with that. But to some extent, without some understanding of the type of procurement, if any procurement, you know, has already been undertaken at the time the aggregation plan has been brought in front of the commission, there would be perhaps some results that could be compared, and with, you know, the SOS procedures typically tell you how much energy has been procured. You may have a number of piece of information that would allow you to determine, you know, based on the procurement that's occurred thus far from the CCA, or based on the estimates we're receiving from, you know, whatever various consulting services they're using to assist them with the procurement. That's what this is attempting to, without having, you know, much of a structure upon which to sort of base this, give the commission what we thought was the desire to be able to establish, upon approval of the procurement approach and the aggregation plan itself, whether or not there would be some some ability to make a judgment as to whether or not there would be success in saving customers money. So I think that was our understanding of how this language would be used, not in any way to be assured of some form of a guarantee, but as part of the evaluation of the aggregation plan, there should be some information that could be considered as to whether or not the aggregation plan is something the commission should in fact approve. So I think we're all sort of trying to determine what is the correct way to approve an aggregation plan when you're talking about, you may not know the actual price customers are going to pay, but to the extent you're sensitive to defaulting customers to a rate, and you're attempting to review the procurement process, if not the actual results, which the commission has already decided not to do. This is how we craft a language that would attempt to have that information, perform that type of evaluation.
So, Commissioner Richard, I mean, you were here, so I mean, you have a view on this, or?
Well, the view I had, and I think it was then too, and I may have been a contrary view from the other commissioners, but I believe your premise of your question was correct. I think that the language that's being proposed by staff goes beyond what's required in statute. I think we're looking at in statute is a methodology, the process by which the aggregation and the program would be set up. And there is no guarantee here. It's simply, laying out that there is thought going into, cost. And again, I think the statute is pretty clear, and I would agree with the county that this O2 section goes beyond and is somewhat redundant with what is required and is provided for in one. So.
Commissioner O'Donnell, you have any thoughts on this?
Not right now, Mr. Chairman. I'm developing a thought, but I'll hold on to it for now until I can fully develop.
Okay. All right, well, I think the consensus view of the commission is that we're not going to adopt this proposed language by staff regarding what needs to be described, and we'll support what the county wants to do.
Thank you, Mr. Chair. One sub-related issue in Regulation 2 can stand on its own even if the Commission strikes Regulation 2, and this is the Retail Supplier Coalition proposed language to add a requirement, impose a requirement on the CCA regarding low-income supply offers or the energy assistance household. And the reason I say it can stand alone is because there are overlapping chapters elsewhere in these regulations that mention would impose or propose to impose this low-income supply offer requirement. So, in a nutshell, in the June session, the Commission ruled that the CCA is, because a unique creature of legislature, the low-income supply offer rules that the Commission recently adopted that would require any retail supply electricity offer, gas offer presented to households or customers that receive low-income energy assistance. Energy assistance households, that they meet or beat the SOS pricing. But the Commission decided at the June 1 hearing that this requirement did not apply to the CCA specifically because of its unique nature in the statute. So, in their comments, the Retail Supplier Coalition has proposed that the Commission reconsider this decision, and if so, there would be language that the Coalition offers to insert in other areas of these proposed regulations. So, Eric Wallace is probably ready to add his comments.
Chairman, Commissioners, this issue is one that's both a market issue and a consumer issue, which is the intersection between the legislation that enacted the energy assistance shopping restrictions, and the Commission recently underwent the RM 78 rulemaking process to implement those with respect to retail suppliers, and the overlap between that and the CCA and the offerings that the aggregation supplier will be facilitating through the CCA. And the Retail Supplier Coalition's position is that, again, both entities will be operating in the same market. There will be an aggregation supplier. The statute says a licensed retail supplier, and those are the entities that the Section 4-308 energy assistance requirements apply to. But that aggregation supplier will be offering to provide the CCA and its customers with electricity supply, and so the Retail Supplier Coalition's position is that there's nothing in that statute that exempts a retail supplier when it's acting in its capacity as an aggregation supplier for the CCA, and that as for kind of parity in the market, that a retail supplier that is operating as an aggregation supplier should be, complying with that statute and ensuring that, the offerings that it is using to serve low-income customers comply with the statutory requirements. The key one being this SOS pricing cap. And I know that in the CCA statute, it talks about designing the aggregation plan to save customers money. And with respect to non-low income customers, there may be some flexibility there, but when you read both statutes together, that that the low income customers within the county that are served by this retail supplier that is operating as the aggregation supplier should be complying with that statute. And so this is an issue that we had presented. It doesn't prohibit the CCA's aggregation supplier from serving low-income customers. It just would require that they comply with those requirements when they are doing so. And so we'd ask that the commission adopt the language that we proposed that would implement that with these regulations.
All right, so it strikes me that, as was mentioned earlier, there's specific language in the CCA statute that says that the CCA is not a retail supplier. There's also language in here that that discusses energy assistance, and it says that the commission is supposed to establish procedures so that customers receiving electricity from the CCA are able to get assistance from the programs offered by the Office of Home Energy Programs, so the LIHEAP program and those things. There's no mention in that section, though, about applying this low-income restriction program. And it strikes me that the two committees in the legislature that approved this piece of legislation also approved the retail supplier low-income restriction legislation. And in fact, they did it during the same session. And it strikes me that if they thought this rule should apply to the CCA, that they would have actually included it in the CCA legislation. And since they didn't, it's my view that this doesn't apply, and it's my view that we don't need to reconsider this decision. Now, if anyone has a different view, I'll entertain it.
I think your assessment of the legislative intent is correct.
All right, I guess with that, we'll move on.
Okay.
Yeah. Well,
That's what I'm thinking.
wait, you know, probably, I'm going to go to 5. Do you guys want a break before then? What's that?
If we took a 5-minute break now.
Okay. So we're going to take a brief 5-minute recess. So,
Okay, thank you, Mr. Chair. We're moving on to the issue of the issue and contested concerns around the opt-out notice. So this, I'm referring to Chapter 4, which relates to transfers of service. And let me go ahead and share my screen. Okay. Chapter 4, Transfers of Service. This chapter addresses transfers of service, including the transition of customers from SOS to CCA Basic Service and CCA Optional Service, as well as new enrollments after the initial CCA transition. Notably, this chapter covers customer opt-out from the CCA pilot, including sending CCA opt-out notices to processing of customer opt-out selections. As you will see in Regulation 1A, there are just wordsmithing here, and I think that's some low-hanging fruit, if you will, that I think we can go ahead and work our way through quickly. If you were just to look, you'll see staff's language in blue, county's language in green, and it's really just for the purposes of A, we won't get to B yet, but purpose of A, commission just deciding which one they like to go with. Oh, let me put this in a little context. My apologies. The dispute in A concerns the permissive versus compulsory language and a time frame in which the county can request customer information from the utilities. So, in its comments, Montgomery County withdrew its general objection to include 1A in its entirety, but the county, I believe, still recommends that the language in A be permissive, and the time frame the county would prefer to allow for 180 days for acquiring customer lists under Chapter 3, which the commission already adopted. Staff believes that the language in paragraph A should be compulsory and that the information request period should remain at 90 days versus 180. This way, to ensure the most recent data possible is transmitted. So I'll leave it to the parties.
I mean, this gets into the mechanics of performing the transfers. There's a lot of milestones and tasks that have to be performed. There are other provisions within the regulations that enable the county to that enable the county to request information for other purposes. In this case, it's the same information. So there's another provision that enables us to obtain this same information earlier and on an ongoing periodic basis. So by the time you get to this point of 90 versus 180 days, either one, we already have the ability to request this information anyway. So for that reason, we don't believe this is necessary. Now, if the commission desires to keep this provision in, our request is that you make it may instead of shall, because if we need it, we already have the ability to request it. If we don't need it, we don't want to have to request it just because the regulation says we have to request it.
Mr. Vanderhayden.
Thank you, Mr. Chair. So this issue really is about when the opt-out notice goes out. I know there's some of this isn't just an artifact of like multiple attempts to edit some of this. So the opt-out list requires the name and address and the various information that the CCA gets from the utility. I think we have advocated for 90 days here with the understanding that we believe that 60 days prior to the start of the CCA service is the minimum time, the appropriate time to send the opt-out notice. Acquiring the data at 90 days is simply 30 days before that, and allows the CCA to sort of process that and get the information from the utility, make the request, and then process it so they have the ability to send that notice by mail, which is how it's perceived as being sent to customers at 60 days. So really the major issue here is not the shall or may or the 80 or 90. What it sort of keys off of is whether or not the CCA is going to send that opt-out notice. And there are two notices they get. I think we mentioned before. They get a notice at the beginning when they announce the CCA, and then at the opt-out notice itself is the second notice they'll get from the mail, which is going to give the customer, all the information they're going to need to make the decision to opt out or stay or do what they want, including things like the prices and that sort of, and all of that is listed, further down in this section B. But it's really the issue is whether or not it's 60 days prior to the start or 45. Staff believes 45 is too short, and so we're advocating that the notice goes out 60 days. So if we're looking at October 1, which I think is the day that's talked about, this would go out 60 days prior to that. So August 1st would be the kind of thinking of a timeline how it would work.
Right. So let me ask a clarifying question of both of you. Is there an interplay between the 180 and 90 and the 60 and 45? I mean, or can we decide, if we decide one way, does it affect the other?
So a little bit, but not really, because whether we send the opt-out notice under B, 60 days, 45 days, and by the way, it says no less than, right?
Sure.
So it could be more. Obviously, we have to request the data. Now, I mean, clearly we're going to request
Mr. Chairman,
updated data.
Wait a minute, one second.
Yep.
Commissioner O'Donnell?
Commissioner O'Donnell, is there an audio issue?
no, I have a question for the chairman off the record.
If you want, well, why don't you send me an email and I'll take a look at it there.
Okay.
All right. So, okay, go ahead.
So it is a relevant question as to the number of days prior to the beginning of power flowing as to when the opt-out notice is sent. That's certainly a question worth discussing. I mean, we believe it goes without saying that in conjunction with the utilities, we'll request the most current data as shortly before the notices get sent out as possible. So this is, by the way, an event that won't be happening for like almost 2 years from now. We're talking about 45 or 60 days before the day power flows. This is quite a long ramp up period from where we are today until power starts flowing under the CCA. So this is that last opt-out notice that goes out relatively shortly before power flows. That's what we're talking about. And, if as we start contracting with our vendors, whoever we select to perform the mechanics of sending out the notice, we'll talk with them and we'll say, hey, we want to send this thing out 45 days before power flows. How far so the notice has to be at the doorstep. How far in advance do you need the address list in order to do the printing and the mailing and get it there on time? So if they say we need it a week in advance or 2 weeks in advance or a month in advance, and then we'll be working with utilities to say, hey, once we submit this request, how long does it take you to get us the data? We'll already have known that because we'll have already requested it anyway. We'll marry up those dates, and we'll issue the request to the utilities to get the most current list to the printers so that the mailing list can be as complete a reflection of the customers who are going to have to opt out. So it doesn't make sense to request a list 6 months in advance for a letter that's going to go out 6 weeks in advance, that data will be stale by that point. So that's why we don't want to have to request it 180 days in advance, because we're not going to use it up until somewhere around 45 or 55 days in advance.
Mr. Vanderhayden.
We completely agree with 90 days, if that's what
Okay.
Mr. Krauthammer just said.
Okay. So now we're at this may or shall issue, correct?
Well, so if your lock is in at 90, and it turns out that in order to send the notice out 45 days in advance, we only need to get it to the printer 60 days in advance. But now the list has to be is going to be requested 90 days old. Like, we don't want that list. We want the list that's 60 days old.
Mr. Chairman,
Sure.
why do we even, I mean, you want this provision in here because you want to have the authority to ask for the data.
We don't need the first provision because we already have this.
Well, but
ability.
assuming, so this is a little bit of belt and suspenders, but basically it gives you authority to ask for it.
That's fine, sure.
But why put a date in? I mean,
We agree.
you're gonna ask for the data when you need it.
Correct.
So if it reads, a county may request from the electric utility, data, it's CCA, well, you can figure it out, but basically, you have the ability to ask for the data that you need.
Yes.
I don't understand why you need to put a time frame. I mean, the timing is really about when you're going to put the opt-out notice out.
Correct.
So are you okay with just striking the time?
I think we would be, as long as the utilities don't have any issue with that. And I'm not sure if we take that out, if we're then getting, I don't know how we assure that the date or the information provided, the name and address, people move in and out, is the most up to date. So I think what we, if there was something that said, as soon as possible, before the day the opt-out letter goes out, that something like that would suffice. But I think the reason you've got the 30-day gap between when they request it and when the letter goes out is to allow the utilities time to send it. Now, if I don't know that we've had a technical discussion with the utility folks, but typically they have to use they have to run a report to generate this list, put it in the format. They'll already have done this once when they send the startup notice.
I guess that's one of the advantages of not putting a number in the first part, is that it'll give the utilities, the utilities are back there, so if they have an issue, I'm assuming you'll pipe up, but it'll give the utilities and the county the ability to kind of figure out what's the sweet spot in terms of how quickly the utility can turn over the information, so when is it that they need to request it, and then can that then be used to send out the opt-out notice.
If there was some way where they could mutually, I think the way it's written just to sort of fix it as a particular like schedule, so that everybody knows what their obligations
I'm
are.
wondering if you need to put, it seems like the timing is the 60 days. So that will determine when the county needs to ask the utility for the data, and if it takes them 45 days to get it to them, they'll have that built into when it is that they'll go to the utility and ask for the data.
So this would require the utility to be ready to provide it 30 days in advance of the 60-day date.
I believe there's already a provision elsewhere where they provide it on, I think it's 10 days notice anyway,
Okay,
or less.
then you're going to have competing timing issues.
We're not concerned about obtaining the data.
Okay.
The important issue is really the 60-day or 45-day of mailing. The date of mailing the opt-out notice is critical. The other is flexible to that and can be adjusted as long as both parties are able to meet the technical requirements.
So do we have a problem? Houston? I mean, it sounds like you are okay with the may, get rid of the timing, and then what's the number of days under B?
So the statute requires 30 days notice. Okay, that's the for the opt-out. So we have to provide customers 30 days to make a decision about whether to opt out. We have, in reviewing other CCAs to identify best practices, we came upon at least one which built in an extra 3 days on each side for mailing. So they voluntarily agreed to essentially 36 days. So we thought that was a good idea. So we similarly agreed to 36 days instead of 30 days, a week beyond what the statute requires. Now, at some point, you get to such a long, you get too long, customers forget, they forget, or it seems so far off in the distance, so they kind of like stick it aside, thinking they're going to get to it later. So there's a sense of urgency along with having a current list. 45 days arose because we believe, again, this isn't coming for 2 years still, so we haven't spoken with the vendors who will be processing these opt-outs. But the idea is that, remember, once the notices are sent out, customers can begin returning them immediately. They don't need to wait till the end of the 30-day period. So as soon as they go out, they're going to start coming in, hopefully only trickling in, but they'll be coming in at whatever pace they come in. We'll begin processing them immediately. By the time we get to the last day that we're receiving the opt-outs, we should presumably have received most of the ones, and then at the end, we're only getting the last couple that are trickling in. Now, at that point, with a 45-day, when the notices are sent out 45 days before power flows, and we've got 36 days for the customers to return them, that still gives us a week and a half to process those last couple opt-outs.
Okay.
We believe that's a achievable period of time. Again, the goal is to make everything as tight as possible without introducing opportunities for mistakes, because people are always moving around. Names, people move houses and turn service on, turn service off, whatnot. Now, if it turns out that we need more than 45 days because this processing takes longer than we anticipate, that's why the proposed regulation says no less than 45 days. If we determine we need 55 days or 65 days, that's what we'll do. It's completely against our interest to have unsatisfied customers, obviously. We believe that this enables us to obtain the best results, assuming a best case scenario, while giving us the flexibility to have more time should we discover we need it. That's the basis for 45 days.
And staff's view about 60 is?
Your Honor, the 60 days is taking into account the 36-day mailing turnaround, plus a certain amount of time that is used once the CCA has completed its scrubbing of the list it gets from the utility and processing all the opt-in or opt-out notices it gets. There would only be, I think, 9 days until the first day that the utility begins transferring load through enrollments from the aggregation supplier. So there's not much time to inform the utility of the amount of load that's going to be enrolled. So that's a concern. By expanding it to 60, you would add an additional 10 days to that process. It also, in our mind, allows customers more time to look at this letter, because it's maybe the only required communication they'll get from the CCA regarding the price that they're going to pay. And it may simply give customers time to think about this and make a decision, perhaps with time that they might have to look at other offers that would be available to them at the time, including standard offer service. So we see an advantage to giving the customer some additional time to make the decision, and we don't think that extending it to 60 creates any technical issues, and it may actually provide a little bit more leeway in terms of processing and scrubbing the very large number of accounts, in particular in PEPCO.
And just switching back to the county real quick, I mean, how big a problem is 60?
I mean, we could live with it, but we just prefer, if it turns out that we can do it quicker, we would like to be able to do it quicker.
Any thoughts?
Mr. Chairman, can I add one additional piece of information?
Yes, sir.
This is David.
Yeah, go ahead.
So in Chapter 17, transition to CCA from SOS under Regulation .02, E, 10 days prior to the start of the CCA is supposed to advise the electric utilities on the number of residential and small commercial accounts that they expect to transfer from SOS according to the schedule. So if there's only 36 day, if there's a 36-day period with which customers must reply, if you add 36 plus 10, you're beyond the 45 minimum there. So the data given to the utilities would more likely be an estimate than if there was the 60-day requirement.
Let me just mention one more. David makes a valid point. But again, the opt-outs will begin coming in, earlier, not all at the end. And also, don't forget, customers can opt out at any time. They can always opt out. If they find out, if they get the letter, they put it, aside and forget about it, then they end up getting enrolled. All they have to do is call the utility or the county, and they can go back to SOS.
Anybody else have any opinion about this? Good, bad, or different? All right, well, I'll make a motion that we adopt the county's position of 45, so. And Commissioner O'Donnell, you have a view on this? All right, well, that will go with 45, so.
Yeah, I'm good.
Okay, thank you.
Mr. Chairman, before we leave this section, I just have a clarification suggestion, only because I read the provision several times before I understood it. So this is, it's the same clause in 1, 2, and 3, if applicable. When I read it, I was thinking, well, basic services and optional services if applicable, and then I realized it was referring to optional services. So I'm assuming that's what it refers to. So I'm suggesting that you move that clause to before CCA optional services, so that it would read CCA basic services and comma, if applicable, comma, CCA optional services. Does that make sense? Unless I'm reading it wrong. So do you see the it's under B 1, 2, and 3.
If applicable. And if applicable, CCA optional services. Says copy, cut that, and move it to before CCA optional services. Put it right there.
Just because there's no punctuation, so it was a little confusing to me when I was reading it, and then I realized it was. See, does anybody have an issue with that? Okay.
Good change.
Thank you. Well, I was confused.
Did we get your language in 1A, Commissioner Suchman?
Well, 1A, I thought we were.
Oh, we're just rejecting the entire thing? Okay.
No, you're going to go with a county may,
Right.
and then just striking the timing.
The dates, yeah.
Right.
Okay, I just wasn't sure if that was reflected
yeah.
at this point.
Yeah. I can't really see that from here. So, I'm working on this.
Exactly. Yep. Okay, great.
All right, moving through the regulation, or the chapter. Staying with B, Regulation 1B, the Retail Supplier Coalition has proposed to add the highlighted language regarding competitive resale supply, just requiring that the information be included in the opt-out notice that, currently they have customer can select SOS as well as a CCA service, but then a third line that giving customers information on how they can select competitive retail supply. And Eric Wallace is at the podium.
Yeah, Chairman, Commissioners, very briefly, the statute lays out the contents of the two notices. With respect to this provision, the statute says that this notice shall include a number of items, one of which is information about how to access SOS. The regulation goes a little further. It includes this option of responding to the CCA notice. And so it really lays out both of those options and, to be complete and present all of the available options to the customer, we're recommending the addition of the retail choice options that the customers have with a reference to the Commission's shopping website that it developed a couple of years ago, so the customers can go and be able to compare their various options among these three different paths that are available for retail supply. So
The county has no objection.
Staff has any concern?
No, we have no concern about adding that reference to the choice website.
Anybody else? All right, I think we'll do it, so.
Thank you.
Okay, thank you. Okay, moving on down the chapter, there is one other issue in dispute, and this one does involve alternate language. Okay. Regulation 2 relates to the optional service provision. Governs the enrollment and drop of customers in a CCA optional service. Just to note, the optional service is separate from the default or basic service of the CCA. What you see under, and I apologize, you note that the side comments, the way that the Word document is, it's kind of doesn't align up with where you can see visually Regulation 2 begin. Staff's language is as filed. The process for selecting optional service should incorporate the same level of customer protections available to customers that choose retail supply services. The county's position is that although the county would agree that customers can switch from CCA optional service to CCA basic service and vice versa at any time, the county disagrees with staff's language as filed and instead offers its own alternate language for Regulation 2. The county states that there appears to be a misunderstanding of how customers will participate in the CCA basic service in relation to the optional service. So I will defer to the parties on additional comment.
As Mr. Chen mentioned, there's just a different lens through which this is being viewed. Could be a little bit of some of this may be an artifact of prior drafts and prior understandings of how the CCA would work. But as we discussed this morning and as we've discussed in other contexts, there are no contracts. And customers enroll, which is a specific term of art. They are enrolled with the CCA, or they could be enrolled, with their retail supplier. But once they are enrolled with a supplier, they can then choose among different products that supplier offers. Whatever product that supplier assigns, that customer. The word assign is not a legal term of art, but it seems to be descriptive of what we're trying to convey here. So once a customer is enrolled with the CCA, they will be assigned the basic product, And then if they choose, they can select an optional service. If they decide that they no longer want that optional service, they simply log on to their account or call the CCA, and then they just change their election. They don't enroll in a different product. You're not enrolled with a product, you're enrolled with a supplier. You also don't drop from an optional service to a basic service. Drop is another term of art, the opposite of enroll. You drop, a supplier drops a customer, or a customer is dropped. I mean, they're no longer enrolled with that supplier, no more relationship. If you decide you don't want, more renewable power, you just change your election. So these are the words, these words make a difference. There's a lot of words in the non-consensus text that are just inapplicable to the nature of how the CCA works. And so what we've done is try to capture all of the customer protections that we believe staff seeks in the non-consensus text, and then reword them on the right in our July 7th comments in terms that apply to the paradigm of a CCA. And we're available for any questions you may have.
Mr. Wallace.
Yeah, Chairman, Commissioners, there's one point I wanted to respond to in particular, which is I believe I heard the county say that when you're enrolling with a supplier, you enroll with that supplier and not with a particular product. And that once you're enrolled with a supplier, you can switch around to any of the various products that supplier may offer. In the Commission's regulations for retail suppliers, you're required to get consent for the specific product that a customer enrolls in. So if a customer were to switch, enrolls in a 1-year fixed price contract, and they look over and they say, oh, you've got another 2-year fixed price contract, I want to extend my pricing for another year, you have to get consent from that customer as if they were enrolling again anew, and provide them a new contract summary and have a contract that reflects that new term. And so I think that concept should also apply to these optional services where there is a process to obtain that customer's consent for that specific product that they're enrolling in, and that's how it's been working with retail suppliers since inception of choice.
Mr. Wallace, thank you for that point. We agree with your characterization of how it works. In the provision that we propose in O2B, it says in response to the type of affirmative action that's required, it says a CCA may assign a customer to optional services only upon a customer's affirmative request. So we can't just be moving customers around between different products. They have to affirmatively request which product they want to be assigned to.
If I may, one additional point. I think the difference here that stands out is that, affirmative request is kind of a vague term, right? And is that customer then provided with, the terms of service specific to that different product offering? We don't yet know what the different product offerings might look like. There's some flexibility for the county to develop different things and decide what suite of different offerings they want to include in their aggregation plan. But something like this that just talks about affirmative request without tying it to a process to make that affirmative request and the disclosures that are made to the customer along the way is a sharp contrast to what's in the referenced retail supplier rules for consent for product changes.
Mr. Chairman, I'm assuming the county, when it submits its aggregation plan, is going to have a description of the different products. And so, I think that the person who making the affirmative switch to a different product will have all of the information available to them, and information that we'll have already approved. Mm-hmm. Am I correct in?
So the specific the specific product offerings will likely not be fully developed when the aggregation plan is filed, because power won't begin to flow for 2 years after the plan is written, potentially 18 months to 24 months. But we will certainly be able to describe the different types of product offerings. There will be more renewable, less renewable, in terms of like what percentage wind versus solar versus other fuels. It remains to be seen with specificity, but we'll describe them in general in the plan. And then as we move forward, we'll be able to have more information that will be presented to customers. But no customer will be enrolled in any optional services automatically. Any customer that takes no action and is enrolled with the CCA will be enrolled only in the basic product.
Can I also just add one thing to it that I think addresses Mr. Wallace's concerns? In our proposed language, aside from only assigning a customer to optional services upon their affirmative request, the means by which they do that is going to include the CCA providing notice of the terms and conditions. They can select it at any basic service at any time. The CCA shall record the date and time of all customer selections, and they can initiate a drop at any time. So we've built in those guardrails, I think is how you described some of this earlier. We're not planning on switching them without their permission, and we're going to let them know what they're getting.
Any questions?
Commissioner O'Donnell has his hand.
Oh, Commissioner O'Donnell, go ahead.
So I need a reminder here. Will the CCA be offering as part of its basic service offerings variable rate products? Are they all going to be fixed rate?
The specific product offerings have not yet been defined.
So they could be variable rate. I'm sorry.
One moment, Commissioner O'Donnell, please.
Commissioner O'Donnell, I don't think we anticipate offering variable rates. In the event that we did, that would be clearly stated in the terms and conditions, but that's not our anticipation at this point.
Well, so I'm trying to remember it. I seem to remember being told that we will not be offering variable rates as we get going, but we reserve the right to switch to offering variable rates. And I'm wondering if that will mirror the kind of retail supplier kind of practice of an introductory offer followed by at a fixed rate followed by a variable rate automatic shift. Is there any of that potential here? Can that happen?
No.
No.
That's not our plan.
That's not going to happen.
No, it might not be your plan.
No.
Per regulations, can it happen? Listen to my question.
We will
Can
not.
it happen?
We will not be offering variable rates.
There will be no variable rates. That will
What
not
stops
be
that?
that will not be
What
the
stops that? What prevents that? Show me where.
I don't think there's a provision in the regulations right now. If we want to include
Yes,
one,
so I'm not asking you if you're planning to. I'm asking you if you can. Is it possible?
and I'm responding to your question that there's nothing in the regulations that says we can't. But if we should put
So the
something in the
answer is
regulations,
possible.
we can do that.
There's not going to be, Commissioner O'Donnell, there's not going to be an introductory rate if that's what you're asking about.
What legally protects the consumer from that practice? Anything or nothing?
Again, if there's language that we should put in the regulations saying there will be no variable rates, let's do that.
Yeah, let's do that because I don't have a good feeling about this. I really don't. And I think this is how a county could go bankrupt, to be honest with you. You get a derecho and you got, man, you're setting yourself up in a big way. But if you preclude that, then you're not, your risk mitigation is high and your risk exposure is low. So that's my suggestion. I've been it's been bugging me for a while about whether or not you're going to be offering fixed rate, variable rate. And I got the same kind of nebulous response before. Well, we don't plan on it. I'm not dealing with plans. The greatest laid plans of mice and men, right? The road to hell is paved with good intentions. I need to know certainty in regulations.
Commissioner O'Donnell, the intention is certainly not to be nebulous. It's
Maybe it's in the future to be nebulous.
No, the intention is never to be nebulous. At this point, when it's still so early in the process, it's very difficult to answer certain detailed questions with a high degree of specificity simply because...
I'm not buying it. Sorry, I'm not buying it. That's a fundamental question. It's a fundamental, basic question.
I think it's fair to say that the plan will describe what the basic rate will be like. And so by the time
it's fair to describe where consumer protections are inserted here to protect consumers from being offered variable rate products.
Right. So it seems reasonable that when the plan is submitted first to the public and then to the commission, it will describe what the basic rate will be like. And if the changing something like a flat basic rate to a variable rate would, I would argue, be considered material. And so that wouldn't be something that we would undertake to perform. Also, of course, it could run into resistance and.
We're right back to where we were the last time I was speaking to you, which is you don't listen. I want to put it in the regs.
I think we should put it in the regs, that there will be no variable rate.
Good. Now you heard me.
So, Mr. Chairman,
Said that earlier.
can we put this in section or chapter 11, which is the aggregation plan requirements? So when you submit your aggregation plan requirements, that will be an element of you've got like 18, so there'll be a 19th.
Yes.
Okay.
That's fine.
So we're going to add language to that effect.
If I could weigh in 1 second. I mean, we definitely support the intent of this. I think it might be necessary to define what a variable rate is if you're going to have a provision that prohibits it, because, is a time of use rate a variable rate? If right now, SOS rates change, periodically. Is that a variable rate? I think the concern here is about, teaser rates that we see from retail suppliers. Customers sign on for, they see a low rate. They don't understand that it only lasts a month or 3 months. So I think, I guess I would just suggest care be taken to maybe define it.
It's very clear in this space what a fixed rate product is and what a variable rate product is. Very clear, Mr. People's Counsel. It's very clear. It has been since 1999. But we haven't done the definition section yet, so we can define it when we get back up there. That feels better.
Well, what I can say is that for all the time that the county's been working on this, the only expectation has been that the basic product would closely reflect, if not mirror, the SOS, the structure of the SOS product.
Oh, I have asked about this before and never really got a clear answer.
Well,
this is what happens when you don't get clear answers when you're doing rulemaking.
So since we're going to be meeting again, maybe this is something that the parties here can sort of noodle over the next couple of days and get back to us with some language that reflects the concerns addressed by Commissioner O'Donnell. Does that make sense?
Yeah, I guess, and I'd append to that suggestion, and maybe, you broaden it to include staff and maybe the utilities and help crafting whatever this language is, so that you don't, preclude stuff that you do want to do in a kind of broad, vague definition of what this thing is. So.
With regard to, yes, certainly, Chair Hoover, we will definitely take that request. Yes,
Okay.
that direction.
Sure.
We will do that.
Okay, thank you.
With regard to the proposed language for section 02, that enables the CCA to offer optional services. That we may assign a customer to optional services only upon the customer's affirmative request.
Right.
That a customer can select optional services through a means which includes the CCA providing notice of the terms and conditions. A customer may select CCA basic service at any time. We will record the date and time of all customer selections, and that a customer may initiate a drop from the CCA at any time. Is that language that we could move forward with today, pending us
So
getting
this is
back?
David Hoppick. I have a question on C that I would like to ask prior to that question being posed.
Okay. All right, go
So
ahead.
C says, may I go forward, Mr.
Sure,
Chair?
sure. Yeah, go ahead. So,
A CCA customer may select optional service through a means which includes the CCA providing notice of terms and conditions. So my non-lawyer mind doesn't understand how, what I read this is, there's some mechanism, electronic, what have you, where they send notice of terms and conditions, and that is the customer consenting or affirmatively selecting an optional service. I don't see how that is an affirmative selection of an optional service.
As we've discussed, there isn't a lot there. There isn't a lot there when you're talking about terms and conditions for these optional services. It's basically a commitment that the CCA is making that if we provide a more renewable content product, that the energy we procure will indeed be renewable energy. I mean, other than that, there's not, I'm a little bit on the spot here, speaking off the cuff, but there aren't all the general terms and conditions that one generally thinks of when thinking about energy products.
I think also the intent of that language, and maybe it needs to be reworded a bit, but the intent of that language was if someone signs up for an optional product, whether they do it online on the CCA website, or they call somebody up at the CCA, that they can be provided the terms and conditions. So that it's clear when they're signing up for that, that they fully know what they're signing up for. So if the language needs to be tweaked to make that clear.
Yeah, I would suggest that it needs some editing, because I think as now it doesn't read as, Stan, what you suggested, whereby I think what you said is if you select this optional service, we'll send you the terms and conditions. That's not how I read it as written on the page.
Well, I guess one thing you can do is you can actually combine B and C, because it's a little redundant. So if B could read, a CCA may assign a customer to optional service only upon customers, or upon, I get rid of only, upon a customer's affirmative request, at which time the CCA will provide the terms and conditions of service to the customer.
Yeah, I would think it. We can probably work on that language.
So you combine B and, you'd get the terms and conditions when you.
What?
Or would you get, you'd get the terms and conditions as a request.
Well, no, you would know the terms and conditions before you, so I just
Right,
want to make sure that's going to be available. Someone's going to know what that optional service terms and conditions are before they make the selection.
I mean, the terms and conditions are no minimum term, no early termination penalty, those are the terms. I mean.
Right, but it sounds like B and C will happen at the same time.
Okay, I would argue that the provision of terms and conditions would happen ahead of time. In other words, that's going to be on the website, for example. You're going to, here's an option you can go to.
Okay, so then you're not providing notice of the terms and conditions.
We are providing it. We're making it.
When are you providing that?
Well, on the website, I showed some examples this morning, for example. We may have a product that is 50% renewable energy. It would show the price, the term that's good for, and someone can go to the website, see that, and say, oh, I want that. I want to affirmatively choose that. They can contact the CCA and say, I saw the 50% option. I like that option. Can I sign up for it? Yes, you can. but they will have already been given the terms and conditions through the website. What we're saying there is, if someone were to call up and say, I don't have internet service, but I understand you have a 50% product, we'll make sure that we give them terms and conditions. We can mail them the terms and conditions. We just want to make sure they
Okay,
understand what they're signing up for.
I guess then, I think maybe adding it is confusing people. Because it suggests that you're doing something that you would not be doing except for having it in the, I mean, I'm sort of wondering if we're just, if by having C in there, it's just adding an unnecessary level of obligation which you're going to be sort of doing anyway.
How about if we say, A, a CCA may offer optional services. B, the terms and conditions of all optional services shall be available to customers. C, a CCA may assign a customer to optional services only upon the customer's affirmative request. In other words, we're stating right up front that the terms and conditions of optional services
All right.
will always be available.
All right, that actually makes sense. Because
I
it
think that works, yeah.
follows
I think
better.
he's got some recommended language for the new B, so take, so, what's your language? Here, it's take.
Off the top of my head, it was
the CCA shall provide,
terms and conditions of all optional services.
A CCA shall provide terms and conditions, or shall make available shall make available terms and conditions for all optional services. And then we can wordsmith it. Okay, then I think we get rid of C.
No, C's still there.
Oh, C still stays.
Because you,
Oh, we'd take,
I'm sorry.
we'd take out the, which includes a CCA providing, take out the.
So this is David, on B, do you want to say something, because optional services, you've told us may change. So a CCA shall provide available terms and conditional for all optional services available at this time, or, right? Because, 3 years from now, you may come up with a new optional service, right? And you won't maybe know that for a while.
Well, currently provided optional services.
all existing optional services.
I mean, seems implied, but for all current. Okay.
Available?
Well, no, because they may not be available, but they may still be enforced.
All right.
This is all covered. 20.3403C. I don't think we need, do we need C anymore? Yeah.
I mean, so optional services is a defined term. I guess adding a qualifier doesn't seem to make sense because you're only going to have optional services that are available.
Yes.
So adding that doesn't, I'm always one to try to put in as little as possible, and especially if you've got a defined term. If you have a question about that, I would look to the definitional section to.
If it just says to make available terms and conditions, that seems to be a reasonable statement itself. I think one could understand what that means.
Right.
If an organization is required to provide its terms and conditions, people can understand what that means. Huh.
Yeah, I don't think we need
No, we don't
the
need that
old
one
C anymore.
No.
Yeah.
Yeah. Yeah.
This is David again. Don't you need an F? A customer may initiate a drop at any time.
Yes.
Oh, yeah.
It's actually at the end of E above, but that's okay.
Right. And then take it off of what's above it.
Yes.
Yeah.
Commissioners, this is the language before you now. If that is agreeable. In the green.
In the green, yeah. That work? Does that work for you? That okay? That work? All right, I think that.
Commissioner O'Donnell?
Oh, Commissioner O'Donnell, go ahead. So.
I'm good.
Okay. Looks like we have a winner, so.
Okay. Just want to clean this up.
So Joey, this is David. I have one, like, totally minor edit, but there's a typo edit. Let me characterize that. It's in 01 when you're done. So 11.
Is it the Comar reference?
B11. B11. Scroll down a little more, please.
B11. Okay.
So it says there's apostrophes where it's supposed to say CCA. We're missing an A.
Got it.
I think it's got 2 apostrophes.
Yep. Clean that up too. And can I have staff just double check this Comar reference? This was also a correction, I believe. This one right here.
It should be 20XX.03.04 C.
Okay. That is
Phil,
what
do you
it's-
agree with that?
Yeah, I think we changed it to 04, so that should be correct.
Okay.
Yeah,
That is
we
what I
changed
have.
it from 03 to 04.
Excellent. That is what I have. Okay, Mr. Chair. I believe we can move on to issue number 6. And that'll tee up chapter 7. Chapter 7 establishes the customer protection requirements, which include, for example, cross-reference to the data privacy chapter, which is chapter 16, creditworthiness, customer deposits, enrollment dispute procedures, advertising and solicitation, notice requirements, and website information. There are 2 issues in dispute under this chapter. The first one relates to advertising and solicitation under Regulation 7. Let me just enlarge this a little bit. Regulation 7C specifically generally subjects the CCA's marketing activities to the requirements of Comar 20530707 and 205310 for retail suppliers. Regulation 7D, as in David, speaks to required disclosures, including the CCA aggregation supplier's Maryland license number on which the parties disagree. Staff's language is the one that you see on the screen as filed. That would require that CCA customers should be able to determine the CCA's aggregation supplier. The county objects to 7C. Insofar as some things in the listed Comar references here, 20570707 and 205310, are already included elsewhere in these proposed regulations. The county also objects to any requirement that it must disclose its aggregation supplier's license number. In the alternative, the county proposes alternative language to Regulation 7C, as well as 7D. So to probably take up 7
7C first.
Yeah, okay.
The county's language is in the comment bubble. It says, a CCA shall conduct any marketing subject to the rules in, and their COMAR references are different than what staff has. Subject to the rules in COMAR 2053-0707 with the exception of COMAR 5370707B1 and subject to the rules of COMAR's 2053-10.
So, what is 2053-0707B1?
That is, if I may,
Sure.
that is a disclosure requirement under the advertising and solicitations section, and it states as follows. It's relatively short. It's short. All supplier marketing or solicitation information, including that used by its agents or employees, shall include the supplier's Maryland license number in a clear and conspicuous manner. That is the key objection that the county has. So every supplier in Maryland is licensed by definition. The CCA is not a supplier. We do not have a supplier license number. We have an identification, where the Montgomery County CCA or CCEA, whatever the name ends up being officially. The purpose of requiring suppliers to include their license number clearly and conspicuously in advertising materials, of course, is so that, if a customer has a complaint, they know who to, who to report or who to call for questions, or if they want to sign up with that supplier, they know who to call. Like, it's not only, for negative, it's also for positive. It's good to have this information so customers know who to find. The CCA will be engaging a licensed supplier as the aggregation supplier for essentially like back office functions to perform wholesale market functions, technical matters that are not within the county's day-to-day expertise. This includes like interaction with the utilities, interaction with PJM, soliciting, buying power, a lot of very mechanical information. It will not be a customer-facing entity, however. They will not be setting prices. They will not be deciding what the products will be. The product offerings and the price will be determined by the county. And so it would be confusing and misleading to provide the license number of a company that is not public facing, that's providing back office functions as the organization that a customer should call if they either want to enroll with the CCA or have a complaint against the CCA. Furthermore, providing that number would provide some might say unfair advantage to whoever has that aggregation supplier contract, because it might seem like an endorsement. Now, this is an organization, it will be publicly known who the aggregation supplier is, of course. It will be included in the formation, the opt-out notice. It'll be in the opt-out notice. So it's not like it's secret information in any way at all. But it doesn't belong on advertising. It might give this, this impression of seal of approval, if you will, which, we're sort of neutral. We don't want to either give that or not give that. Being the aggregation supplier shouldn't convey any additional, messages other than it is what it is. I hope this provides some context for our objection to the use of the back office supplier's license number and our request instead to use a name that the county decides to use, which would be, Montgomery County CCA, or ideally, some minor substitution if we decide to change the wording around slightly. Community energy aggregation, possibly, for example, as opposed to community choice aggregation. We don't know.
Staff.
Your Honor, I think it's as simple as, the idea of customers are buying this energy from the CCA, but it's being sourced from another company, and that company's earning a profit on it, and maybe it's something that customers are interested in understanding what the source of their energy is. So the description of the aggregation supplier as a back office, they're not simply providing like data services. They actually have to source the energy, and they have title to it until it's purchased. So there's a little bit more to it than that, and I think some of this is still a little bit unknown to all of us because we're not entirely sure how the procurement's going to work and what those relations will look like. But generally, a retail supply number is something that is, I mean, they're long numbers, but they're usually printed somewhere on a brochure or on the website. And what we would expect to see here is that your energy is being provided by the Montgomery County CCA, from this supplier, and that is probably it's public information. It's not. It would be provided to the customer on the opt-out notice. So we didn't see any reason to not incorporate that, because there are customers that when they do the retail supply shopping, conceivably they know which supplier they have used before, and they may have an interest in knowing if that supplier is providing this service.
But isn't their situation more analogous to what the utilities do when they purchase supply for SOS?
No, because that's a wholesale relationship where the retail supplier is a retail relationship. They're required by the law to use a licensed retail supplier, whereas SOS is provided by a number of, probably like 5 or more, wholesale suppliers that are under a very different arrangement.
The aggregation supplier is not necessarily the sole supplier of energy. The aggregation supplier will be providing a service to the CCA to go to market, find pricing, and procure power. So there will be, you're right, Chair Hoover, we expect there will be multiple bidders providing power to the aggregation supplier. It is possible that the aggregation supplier could self-provide if the aggregation supplier owns generation resources, but it will also solicit bids from the market.
Mr. Wallace, and then we'll turn to questions.
Yeah, Chairman, Commissioners, I think one thing that has been kind of a persistent area of ambiguity here is what exactly the role of the aggregation supplier will be, and I think we've heard some different versions of that as the various phases of this rulemaking have progressed. And so I think what I heard today is that the retail supplier will have no interactions with any customers in the county. Am I hearing that right? There's not going to be a call center operated by the aggregation supplier?
Right, so it's not, it has not yet. It is possible that we will utilize the call center operators provided by the aggregation supplier. There would be a dedicated phone number. The agents would be trained so that when calls come in to that particular number, they would answer the call with something like Montgomery County CCA. How may I help you?
And presumably the supplier would be the one that would be, pursuant to 2053-10, that would be training and managing those call center reps. I think the Retail Supplier Coalition has supported staff's language here. I think the key things are maybe not from our perspective, are not necessarily the supplier's number, but the other components in the referenced 2053-07, 07, and 2053-10. That would govern those agents, and there's one kind of tie-in to Part D that's the highlighted section there in the middle that references including, it says including that used by agents and employees, and the concern there is the tie back to 2053-10, which is the supplier agent relations provision, and so there's a comment in yellow on Part D about removing that phrase. And that comment actually has been addressed as long as we have the cross-reference to 2053-10. So I think the concern was that there would be agents and employees of an aggregation supplier or a CCA that would be interacting without being subject to 2053-10. bottom line is, we're okay with that provision, and we're also okay with, we like staff's language, but that, to the county's point, that provision about B1, I think, is not as critical as the other pieces in there. But certainly we would, wouldn't have any opposition to including it there. We just want to highlight that it's those other things that are really more important to the Retail Supplier Coalition.
I guess, I would be interested in the information if the entity were doing more than just backroom. And I'm not really sure quite what backroom means. I mean, earlier in the day, I talked about the term energy service provider, and we don't have a definition for that, working as agent of a CCA, and that could be an administrator like the New York administrator, which is clearly doing a fair amount of stuff, and that kind of knowing what that entity is and having information about that entity is, I think, important. If we're talking about an entity that's function is fairly ministerial and pretty limited, maybe we don't need to know that entity's license, but we certainly need to know the license of an administrator if the county ends up hiring the administrator. So I guess my question is, is there a way in which we can sort of define this to require the kinds of information that you need here, where the entity is performing the function that looks much more like an operator of the program as opposed to an entity? I mean, to the extent that the aggregation supplier is doing a pretty limited amount of things for you, maybe we don't need their information. But to the extent that an aggregation supplier starts to look more like an administrator of the program, certainly I think that information, the information about its license and identification of the entity is going to be more important.
We had another slide put together. We didn't end up showing it this morning due to time, but we've shared it with the work group, and it shows a spectrum or a progression, if you will, of different models. And in some, the aggregation supplier provides a lot of functions, like the ones you're describing. They basically run the program. And then there's the middle, which is what we're planning to perform, which is where the aggregation supplier acts at the direction of the county, who makes all the key decisions. And then at the other end is where the county or the CCA does everything by itself, including the wholesale market functions. I hope that perhaps those three different variations perhaps provide some framework for you to kind of visualize, where the aggregation supplier is positioned.
Well, it sort of doesn't. I mean, I'm looking at the definition of aggregation supplier that contracts with the county to provide electric supply service.
Yes.
So it's selling you power.
Correct.
Okay. So if it's just doing that and you're buying power from several aggregation suppliers, and that's a possibility that you can, or are you thinking that you're just going to deal with a single, I guess aggregation means you're gathering together. So are you anticipating that you're going to deal with a single aggregation supplier? They're going to go out and get the kinds of power.
There will be a single aggregation supplier, but I wouldn't want to opine today on like the nature of generation owners or anything like that. That's premature to that kind of detail.
I mean, I'm just thinking that maybe to the extent we ever get a definition for energy service provider, maybe that can start to get to entities that are not the county, but are more than just an entity that's getting your power, and is performing functions that I think would suggest greater transparency.
So perhaps not perfect analogy, but I think it applies. Trash collection. So the county provides trash collection services to a lot of residents, and if a customer, I obtain trash service collection services from the county. If I'm not happy with the way they leave the cans, after they empty them or whatever, like I'm not calling the number on the side of that truck. Like I'm calling the county. I don't even think there is a number on the side of the truck. But either way, I'm calling the county no matter what. It wouldn't even occur to me to call anyone other than the county, because I know they're the ones who are responsible for this. It's the same idea here.
Well, my sense is that the administrators in New York are the ones that sort of interface with the customers, and you're going to call them and not necessarily the municipal system that hired the administrator.
With this is I don't want to speak to a particular other jurisdiction, but what we can say is we've been very, very clear for a very long time about the buck stopping with the county.
I think that's fine. I think the concern maybe from the retail electric suppliers, and maybe from me as well, is that we don't want you at some point, and not for any nefarious reasons, but we don't want you sort of hiding behind an entity that ends up really doing the work, and the customers should really know who that entity is.
I mean, there are a lot of pros and cons to this issue.
Well, I could tell you that if you're really not doing the work and somebody calls the county and the county says, well, we're really not in charge, it's really ABC administrator, that's gonna really upset the ratepayer.
I think the opposite is true. We don't want to hide behind anybody. We want people to contact the county. If there's a problem, it's the county's responsibility to fix it. So that's why we, on all the materials, we wanted to say the Montgomery County CCA, because we are, the buck stops with Montgomery County. I've lost a little bit about what we're disagreeing on here. I think, the provisions in, I forgot the reference number now, but 205310, we agree with. We agree with 2053-0707, except for that one provision that says you must put the supplier's number on everything. That's the only.
We're talking about.
No, I understand it, but not to confuse the issue more, but you said that there's a possibility that you might utilize the company that you hire's call center. So if someone has a complaint, they'll call. So instead of talking to a county employee, they're going to be talking to an employee of the supplier. And you indicated that, that person would answer the phone saying, Montgomery County CCA, which is all well and good, but if the person has concerns and problems and things like that, they're going to be interacting with an employee of the supplier, not an employee of the county, and unless there's some, supervisor from the county overseeing that.
So I will not purport to be a call center expert. But I believe that call centers are outsourced also by a lot of companies. And so it's possible that when you call a call center for, any store out there, I believe that they may likely not be employees of that store.
Right.
But who you want to call is like, who's responsible? Like, who's responsible, whose name is on the product that you're buying?
Right. I understand.
So if it's, Macy's, I don't know, it doesn't matter who the call center is, like it's Macy's. From Montgomery County, and this has been, a subject of recurring discussion, here at the commission and in the work group, that it's very important that the county bear full responsibility for all actions. So we don't want there to be any confusion about, that anyone else should be called or, for anything. It should always be the county.
Can I jump in?
Sure. Yeah.
So the statute actually doesn't require the county to use an aggregation supplier or a service provider. I think there's different places where it says cause its selected electricity supplier, if any, to do different things. So the county, they're saying that they're going to use one. But if you look at the statute as I think I understand it, the provision that says that the county is not subject to the provisions of essentially of Title VII except the RPS, and that all the regulations that we're talking about and that the county is saying it's agreeing to have applied to it are promulgated under that section. So the way I see it is that the county is being incredibly generous here and accepting pretty broad application of the regulations. I mean, I think the county could be here arguing and saying it's not an electricity supplier by statute, and therefore none of those COMAR provisions should be applicable to it. Now, you know, it raises a question as to whether it hires an electricity supplier, but we deal with that, you know, the call center, we deal with electricity suppliers all the time that are farming out their door-to-door solicitations, and we want to hold the licensed supplier responsible for that and not go after the agents. We want to hold that license and it seems very analogous here. The county is saying we're going to be responsible. We're not going to hide behind, and it shouldn't. That should be the way it works. The county should be responsible.
Mr. Chairman?
Sure, go ahead.
I just want to say that I agree with the county on this matter.
Okay.
As do I. I think, the identity of the CCA, that's what the relationship with the customer is going to be with the CCA. So I think to do anything else would, I think, confuse the situation. So.
Yeah. I'm okay with that. I still am troubled by the lack of definition of energy service provider. And I know I keep coming back to it, but I think it's because the administrator seems to function very strongly in lots of different places. And so the one thing I'm a little concerned about is having all the information relating to the county be available, the administrator be essentially running the program, which you say that's not going to happen, but it could happen, and then nobody sort of knowing anything about this entity because it's not required to disclose, or you're not required.
Oh, no, we will be disclosing the information. I mean, the information will be disclosed. It'll be disclosed in the opt-out notice. It'll be on the web. It'll be available on the website. I mean, the information's not being not provided. I mean, if the information's being provided, it just shouldn't be on the side of every bus.
Sure.
Yeah.
Okay.
And also, if I could just ask, I mean, just to follow up with Mr. Lapp, this could be a bundle of services, as I understand what a CCA can be. You can go and have a contractor. The statute also allows the CCA to actually own generation, own storage. It suggests that the CCA can provide energy conservation services or energy efficiency services.
Right.
It also charges the CCA with the possibility of assisting with low-income programs. And so, I mean, the CCA, I think, is more than just a potential, at least as I read the statute, of contracting with a retail supplier. It is an entity in its own, and we've already heard directly from the county that it is an instrumentality of the county. It will be an instrumentality. So the buck will stop there. So I think, again, to do anything here that would confuse the consumer that they should go anywhere or look to any other entity other than the county, I think would undermine, I think, what we're trying to do with the CCA.
Thank you, Commissioner Richard and Commissioner Barbe.
Okay, Commissioner O'Donnell, you have any thoughts on this before we move on? Going once, going twice. Oh, there we go.
No, Mr. Chairman, I am good. Thank you.
Okay, so just to wrap this up, we'll go along with the county's suggestion on this, but in line with Commissioner Sussman's concerns and my concerns, I guess when you give the plan to us, make sure there's enough discussion in there about customer interaction. So if you're using this call center, because I'm very familiar with the call centers that are used by retail suppliers and the problems there. So, if the county's going to own this, make sure you're very explicit in describing to us how you're going to own it. So.
We will, Chair Hoover. Thank you.
Thank you.
So, Mr. Chair, I take that to mean going with the county's
Yes.
recommended language for both C and D.
Yes.
Okay.
Can we just, the language says, it says Montgomery County CCA. Is there a way for us to put in, give us some flexibility in the exact name?
This is your language.
This is in D, this is D1.
I think we said somewhere else. Sorry, I think we said somewhere else that we would have on the bill, when we talked about how to do it on the bill, like.
Out of the MCCCA in a clear and conspicuous manner. Yeah, that's good. And then, that's good. So whatever
It's
the
just-
legal name ends up being is what it'll be. Yep.
Yeah,
Good.
MC is just
Okay,
abbreviation
perfect.
for now,
Yep,
just
yep.
for space
Perfect.
reasons.
Thank you. Thank you for your indulgence.
Okay, just before we leave page 2, there are just a couple nit corrections. They don't appear to present any issues. Then the next topic is regulation 7E is an Edward pertaining to telephone solicitation. And in this, by going with the side comment, you'll see that Montgomery County has already stated that it has no intention of conducting outgoing telephone solicitation. There is an objection by AOBA with regard to scoping of this particular provision, as well as a comment that OPC raises. So I think Fran Francis is available.
Yes, Your Honor. If there's not going to be any telephone solicitations, then why do we need the regulation as written? In other words, originally our concept was if there was going to be a telephone solicitation, I think customers should have the right to opt out of getting those solicitations. We don't want confusion, and I represent commercial customers, small commercial customers. Many of those companies are very large with hundreds of accounts, and someone could pick up the phone at one of the communities and inadvertently say something that's incorrect, not know that all those properties are with a retail supplier. So if there will be no solicitations, why don't we say that in the regulations, or at the very least give, and I only represent small commercial, give small commercial customers the right to opt out of telephone solicitations.
So can I respond to that?
Sure.
So we took the comments made by AOBA and OPC, and in our July 7th comments, we actually provided some alternative language for the existing text.
Yep.
Mr. Chen, I just wanted to make sure, I don't know if Mr. Chen needed me to give him something. So what we suggested replace the existing text in the body right here would be, 1, a CCA shall not conduct outbound telephone solicitations, and 2, a CCA is not prohibited from accepting inbound service selections via telephone. So we were trying to address both AOBA's concerns about telephone solicitations as well as OPC's question about the Maryland Telephone Solicitation Act, which I agree is a very, it's a looming concern. So we just are trying to make clear, we want to make it possible for customers, say, who don't have access to the internet, to make a selection via telephone. They, they need to have an alternative way to communicate their wishes to the CCA. But we don't want that to be considered a Maryland Telephone Solicitation Act violation. So that's why we were trying to be clear that we're we're not prohibited from accepting inbound service selections via telephone.
AOBA has no objection based on what Montgomery County just indicated.
And so what about, well, actually, let me turn to staff first. I mean, if they don't do telephone solicitation, do we need to have regulations about telephone solicitation?
I'm going to let my attorney handle that one, please.
No, we don't. If you have a regulation that says they are not going to be performing telephone solicitation. I might also add that the concept of outbound and inbound telephone calls is not does not define whether or not the Maryland Telephone Solicitation Act applies or not. It can, and that issue is up on appeal now with the now the Supreme Court of Maryland. So
We're happy to accept wordsmithing. We were trying to address the issues but like I said, this was in our July 7th comments, and we are happy to, especially Office of People's Counsel. I know you had the original concern. The comment was yours too. So we're happy to wordsmith, but that was our intent.
We're good with Montgomery County's solution.
Commissioner O'Donnell has his hand raised.
Oh, Commissioner O'Donnell, go ahead.
Yeah, Mr. Chairman, my recommendation is we wait until final court actions are taken on appeal. The courts have upheld us thus far in our interpretation and the Attorney General's administration and interpretation of the Maryland Telephone Solicitations Act. But it may be advisable just to wait until that's completely put to rest before we start adding in, layering in wording.
For my benefit and probably two other people's benefit, can somebody just explain to me what's before the court?
well, there's a lot before the court, but one of the things is that distinction, whether what is covered by the Maryland Solicitation Act and what is not. The appellants, and contrary to what was found by the commission and by two courts subsequently, claim that having sent a postcard to potential customers that says, call us at such and such a number, that when they call, that's now an inbound call rather than an outbound call, and therefore the Maryland Solicitation Act does not apply. The Attorney General's Consumer Division and this commission has said no, as has the Circuit Court, the Court of Special Appeals, and the trial court as well. So,
okay.
The district court.
Your Honor, as I understand the issue before the Supreme Court, and I think that's right. I mean, the issue that might somehow have an implication here would be the inbound-outbound distinction that the retail suppliers arguing in that case. But I'm not sure that affects the language here, because the Montgomery County's solution takes a reference to the MTSA out of the proposal, and the second part references receiving inbound calls, and either the MTSA applies or it doesn't, and the court will decide that, and then there could be an issue potentially, but there are no contracts here that are entered into as we've discussed, so it's hard to. I think there are other reasons why the MTSA may not really have any implications here.
Mr. Chairman, it seems to me that you don't have to put in the regulations that somebody can contact you to sign up for service. They will do it if they don't have the internet. So I'm just wondering if you even have to say that. I think if you just say you're not going to solicit, period. Because, I mean, they're not going to someone's not going to look at the regulations and say, oh, I'm going to interpret that to mean that I can't call them. I mean, you're going to have a phone number that's going to be on flyers. So I'm thinking you just, if you said, we're just not doing outbound calls, period, and then you don't have to worry about the case.
That makes sense to me.
Do we need the word outbound then? Is that?
Why don't you just say you're not gonna solicit?
Okay. So a CCA shall not conduct telephone solicitations?
Well, I guess a solicitation, depending on how one argues, could be accepting an inbound call. I think that's part of the concern. So I think maybe you do need the outbound.
Okay. Do we have any idea when a decision might come?
No, I think it could be sometime still.
Okay.
Anytime.
And what's that?
I think it could be any time. It's whenever the Supreme Court.
I understand it, but we don't really know.
Argument has not been held yet.
No.
Oh, so
there's-
it's not
yeah.
so it's not
Yeah.
imminent.
Yeah,
But
argument is, I believe argument is in September, so it's
so
going to be
it's going to be a while
yeah,
before we find out.
it's going to be a while.
Yeah. Okay. So, Mr. Wallace.
Yeah, I think the important piece here that's kind of standing out to me, and I agree with staff counsel's characterization of the appeals. And there are 3 pending appeals of commission decisions in case 9613, 9614, and 9615 that all kind of build off of this question about what is a telephone solicitation under the MTSA. And there are various permutations of that in those cases, some very broadly saying all inbound or outbound calls, regardless of how it was initiated. So I think that there's some gray area here. The other piece that I'm thinking about is that, to the extent that there's an aggregation supplier involved in this process, they're going to want to understand what the rules are that apply to them, because they are licensed by the commission. They are subject to the existing Choice Act requirements for licensure and penalties and so forth. And if they are not going to be subject to the MTSA by virtue of being in their capacity as an aggregation supplier, I think it just will need to be clear so that suppliers that are seeking to potentially be selected to fill this role know what the playbook is and whether the existing framework of rules is going to apply to them as a licensed supplier, or if there will be a different set of rules here under these regulations. And my sense is that we're heading in the latter direction, but this is one area where there's a very important distinction there that I think needs to be clear.
Mr. Chairman,
Yeah. Go ahead.
can someone explain to me why it is confusing to say that that Montgomery County will not use telephone to solicit and just leaving it at that? I mean, why is that legally confusing? Can someone explain that to me?
The question has been raised because of these previous determinations by the commission and then that have been upheld by the courts so far, that it's not only when a company calls you and says, would you like to sign up for us, with us, okay, and then they sign you up. It's if the CCA sends their notice, their opt-out notice, for example, or somehow another piece of paper, and you respond to that by phone instead of by going on to the website and clicking something, you have signed up via phone. And the decisions, and people can certainly, who know more about this can correct me, but that has been deemed telephone solicitation under the Maryland Telephone Solicitation Act, which then requires a written contract. We don't have written contracts, so we're just trying to make it clear that, we want to allow customers this possibility. Yes, some folks aren't going to have access to the internet. We want to make it possible for them to sign up. But that can't trigger the contract provision because there's no written contract. So it's just, we're just trying to make sure that
Okay.
there's not a confusion as Mr. Wallace said, we're trying to make sure that there's no confusion about what we're required to do.
Yeah, I think it's you know, basically the effect of a coached call to somebody, based on something you get in the mail, that says, that triggers you to contact them, is sort of viewed in some ways as essentially the same as them calling you. And so, even though you're the one that initiated the call, so.
And that's resolved. So the language, Commissioner Barve, you suggested, just with the addition of outbound, I think resolves that.
And Commissioner Barbe, just so I'm clear, I don't have any problem with the question you raised. My question becomes the result of when we start putting descriptors in on what is and is not a solicitation by telephone in accordance with the Maryland Telephone Solicitations Act. Because the matter's on appeal. It's 3 cases originated in the Public Service Commission. It's been litigated back and forth through the appeals process, and it's at the Supreme Court. And that's where you get into trouble. So if you stick to shall not use outbound calls, I don't think you're creating a problem. But when you start describing elements of the Maryland Telephone Solicitations Act, there's where you're getting into dangerous territory, in my opinion.
So you, Commissioner O'Donnell, you feel we just shouldn't touch this at all?
Well, if we can do what you said, which is fine, I don't have a problem with that. But beyond that, no, we should let it alone for now.
So the county suggested 1 and 2 that Mr. Chen has put up there. So we're, if I understand correctly, we're just going to leave it with a CCA shall not conduct outbound telephone solicitations, period, and then delete 2 altogether? Yeah. Okay.
Yes.
And we all understand that to mean, do we have an understanding about what that means for the ability to accept an inbound call where the customer wants to sign up for service?
Remind me.
Do we agree that that doesn't require us, the CCA, to send out a written contract per the Maryland Telephone
Okay.
Association?
Right.
That's kind of the
I would think
concern that's
sitting
hanging out
here
there.
today, the answer to that question is yes. Now, it may be that, a few months from now, that answer will have to change if the court decides something different, so.
Okay.
Does that work?
Yeah, I just, we want to make sure
Yeah, I
that we're being
understand.
responsive to
Yeah,
customers' needs, but
Sure.
not creating kind of a
Yeah.
situation for us. Okay, thank you.
Joey, the correct format is may not. Shall is for when something's required.
So, Mr. Chen, let me ask you this. Are we finished with this particular section and going to be moving on to a brand new area, or is there still something left in this area? And if
We
there
are
is,
done.
how much?
We are done with this regulation. We have one more issue in this chapter 7.
And this is the data privacy thing.
No, the notice of enrollment
Notice of-
under Regulation 9.
Oh, all right.
Yeah, but
Yeah.
as far as advertising and solicitation goes, yes, the commission is moved. Completed advertising
All
and
right, so,
solicitation.
and I don't want to put you in a difficult spot, but can you give me a clue as to if we try to tackle this enrollment issue, is this something likely to go on for quite a while, or is this fairly concise?
No, I think the enrollment issue is just a simple question whether or not the CCA should be required to send a notice of enrollment, just
Okay.
like retail suppliers.
Okay.
Or I think it's utility.
All right, well, I promised people we'd be out of here by 5, so and we're past that, but if people don't object, then we'll try to knock this off and then end for the day, so.
The whole I guess there are the county and OPC share the view that a notice of enrollment, that is, once a customer has enrolled with the CCA, the utility, if I'm not mistaken, would follow up with a confirmation of enrollment like it does currently today in the context of retail supply. That's that requirement. I believe the county would prefer not to have that requirement, whereas utilities and staff are of the opposite opinion. However, the parties do agree that if it's more costly to stop these notices of enrollment, then let's just stick with the notice of enrollment. So
The thought is that there's going to be the robust informational campaign that will be carried on for months leading up to when power flows. Then, roughly 6 weeks prior to power flow and customers are going to get the opt-out notice, there'll be more information provided to the county that, the launch is imminent, and then customers will be enrolled. Ordinarily, when a customer's enrollment changes, that triggers within the utility a letter that's generated, so that they know it's like a check and balance. They receive a welcome letter, presumably from the supplier, but they also get a letter from the utility. If there are any number of reasons why that letter is generated, right? I mean, here there are no unpermitted. No, there's no what's the word? Unpermitted enrollments. There's no here. I mean, everybody's going to be enrolled who doesn't opt out. Right. It's like a mass enrollment process. So to send out 150, 200,000 letters on top of all the other information that's being provided seems to us to be a little redundant. That's all.
Mr. Hoppick.
It could be something else, though. It could, for those of us who tend to just toss everything that comes in, if I got a notice from Pepco that I'd been switched over and I hadn't been paying attention, it would force me to pay attention. So it may be that the effect of this is actually to have a bunch more people opt out because they hadn't been paying attention before. So on some level, I mean, it's kind of a little backward, but on some level, it actually serves as an additional notice, informing ratepayers that they have yet one more chance to opt out if they wanted to opt out.
This is not a matter that is like a 10 out of 10, for us. It struck us as being a bit redundant and, not necessarily the best use of, funds, but you make a very valid point, certainly. We had considered that also.
Mr. Wallace.
Yeah, just very briefly, in our comments on this issue, we supported maintaining the notice. This is a notice that customers get when they enroll with a supplier. It triggers them to be aware that change is taking effect if they had signed up for it sometime before. Likewise, we think this is a way for customers to receive notice not just from the county but also from the utility that this change is happening. And we would hope that would trigger customers to either make an informed decision to do nothing or to look at a retail supply option perhaps, or to otherwise be making a shopping decision when they get this notice. So we support maintaining notice.
Ms. Francis.
Your Honors, AOBA believes the letter should be sent. It's kind of like a last check to prevent an enrollment error, or if somebody has forgotten to opt out or missed the first two notices, this will be it. Now is your chance. Either do it or you'll be on a different rate. So we feel strongly that should be done, just to prevent enrollment errors.
Okay.
David Hoppick has his hand raised.
Oh, actually, let me take Representative Pepco.
Good afternoon, Taylor Beckham on behalf of Pepco. I just want to provide just a little bit of context. So obviously, the letters are already automatically being sent when a customer is enrolled. Whether or not the cost would be significant to stop that automatic enrollment, I don't know at this point, but there is a cost. I just want to let you guys know there would be some level of a cost to stop those notices.
I see. Mr. Kopic. David, you there?
Mr. Chair, apologies.
Oh, no
So one thing I wanted to note was that please keep in mind that there will be, in addition to the initial enrollment, as customers move into the county, they can be defaulted into the service as well. So this would also provide notice for those customers who would not necessarily see the advertising campaign spoken of earlier.
Okay. Anybody else want to be heard on this? All right, I think, while it may be redundant, why don't we keep the letter requirement? I mean, I guess I've heard enough that, it seems to me it can't hurt and, to do this. And as people mentioned, it's like, last chance.
It's not, Chair Hoover, it's not last chance because customers can always.
No, I
opt out.
understand that, but as was mentioned, it's like, look, before we, start down this road, here's one of your final chances. So.
It looks like the commissioners are in agreement.
Yep.
Okay.
All right.
And that's the end of Chapter 7.
All right, and so with that, we will be setting a hearing date in the future. So you'll get notice about that when we try and get everybody together, and hopefully we'll finish up everything at that point. So with that, we're adjourned.